Okay, pass over board. I just files has not been closed.
My lordship. This case is lordship basically filed against interim order lordship. For granting interim order lordship, this issue is this is a land matter lordship. I have applied for land allotment. For regulation of that land allotment, I've applied in the 2021 lordship. Accordingly, as per my application
No,
lordship.
everything is all right.
Yes.
We don't find that you don't have merit in the matter, but you see, ultimately you have received a notice, you'll have to participate.
Yes, on that day there is a specific amendment in the para 6 of my writ petition saying that on that appointed date for hearing of the case, I went to the state officer to reply. I being a layman, I went there, but on that day office was not functioning. Neither next date was informed and nor any action was informed to me. I thought that the matter has been already resolved by the authority. So later on, lordship, I have informed in the form of representation to the deputy commissioner concerned, because deputy commissioner is the overall authority over the land matters. So in terms of law, if we say in terms of law, it is affiliate authority. Even then, when state officer eviction matter and all, he is the overall authority to look after all those administrative matters. So accordingly, on the basis of my this land allotment application, this concerned authority like forest department and all, they have to this NOC, no objection certificate, and guidelines have been framed for regulation of my occupied land. I thought that matter is resolved. So recently, the state officer, eviction officer, that eviction officer has threatened me to evict me out from my area.
Where is
Saying
that notice?
accordingly,
Where is
I
that
have-
notice?
Kindly see, Lordship, my writ petition, I have enclosed my writ petition. Page number 45.
45 is the
Yes,
information.
page number 45. Information regarding,
No, where is the notice of
yes, to Deputy
section
Commissioner.
4? Section 4 notice, where is that?
Yes. I have informed, it is after this eviction notice, there was no any eviction process. It is 2 years old eviction notice. Neither they have passed any order.
But where is that notice?
Yes.
Where is that notice?
Kindly see, this eviction notice is 9 November 2020, page number 42. 9 November 2020, page number
So
42.
you have got a notice, you'll have to give a reply.
Accordingly, Lordship, on the basis of, in the paragraph 6, I'm reiterating,
No, you see, Mr. Tapak, this Shoko's
Page-
notice we are not quashing.
page number, paragraph,
Shoko's notice we are not quashing. We will not entertain a writ petition against
because
the quashing.
at this juncture, Lordship, my prayer is, at this juncture, I have occupied my land. If I'm evicted, even if I apply for that land, I will be nowhere. Because my land application is yet to be disposed by the Deputy Commissioner concerned. Deputy Commissioner, in case of this eviction process, it is next authority is, if the eviction officer pass order, any order, the competent authority to hear that matter is the Deputy Commissioner. And in case of my submission of any application for an allotment, or may it be a regulation of that occupied land, that is the competent authority to consider my application is the Deputy Commissioner. Accordingly, Lordship, I have filed
You see, these are two different,
application,
no, you see. is
because
the-
that is a two things is
Tapak.
interconnected,
Mr.
Lordship.
Tapak, please tell us.
Yes.
Does the state officer give you land allotment?
No, Lordship.
Then
Land-
there are two separate authorities.
I have come before your Lordship on two grounds. One is, I have applied for the land as per the land policy of the state. I am entitled to be verified my land, and if it is feasible for public land allotment, I may be allotted that land. That is one of the ground. And another ground is, when the state officer picks the matter, proceeding was going on, picks the matter on that appointed date, the state officer did not come to the office and responded me, and neither passed any order. Again, then treated me after 2 years, saying that you have not vacated the land still, without passing any order.
Okay,
Whereas,
just
is
let
that
me understand
officer-
your argument. Let
Yes.
me understand your argument. We fix a date for hearing in this case.
yes,
Let us say we are fixing the date tomorrow.
Yes.
Tomorrow, God willing, I am ill, I can't come to court. So therefore, in the cause list has been printed for tomorrow.
yes,
My name is shown to be the judge presiding on the court number 1. And then I'm not there. Now, please tell me who in the courtroom you expect to inform you what will be the next date. In this court, we have 7 or 8 people. Please tell me whom do you expect to tell you what is the next date?
Lordship, in the court is otherwise, in the Deputy Commissioner office, it is the atmosphere is otherwise.
I don't
Generally,
know,
in
the
the case
presiding
of
officer is
file,
not there.
that is-
I don't know. I'm yet to learn because my entire life,
Yes.
practice life, not
Yes.
this life, the practice life was spent in trial court.
Yes,
So if the judge is not there,
yes,
the matters will have to be placed before another officer
yes,
and a date be given, or the presiding officer will come on the next date
yes,
and then pass for necessary orders on a different date.
yes,
That is what I have learned with some experience in trial court.
yes.
You must always also be aware that I was not a high court lawyer. I was basically a trial court lawyer during my practice time. So
That
this is something which I have seen in my entire practice life.
That is, That is why, Lordship, I have prayed before the learned single judge that interim protection may be granted, saying that either interim protection may be granted or direction may be passed to dispose my representation. But the matter was, record has been called for, but no interim protection is there. That is why my prayer was very simple, saying that in just temporary relief may be given before final hearing of the case. Either directly dispose the representation. In the meantime, some temporary relief may be granted. Paragraph. This is Lordship in the page number. And page number 45 of the this appeal. 30 April, one intimation letter was written to the Deputy Commissioner Pasigar regarding this 30 April 2024. In page number 45 of the WP, this appeal. Page 45.
Where is your Shoka's reply? Where is your Shoka's reply?
So of course, Lordship, after 2022, that first so course notice
Shoka's reply.
reply Lordship in the at that point of the in the form of reply I have filed to the being a layman, filed to the this representation to the Deputy Commissioner. But in the after that, after discussing, I have reply has been filed in the enclosed in the this read petition. That
Where
read
is that?
petition
Show us
later
the
on
page.
after when read petition was filed, then later on I have at the belated stage in the read petition after filing read petition. That is why after passing of that impugn order that Toko's reply has
So
been
it
filed.
is- it
That
is
is
not
why I
annexed.
have not included.
On a,
In the
Mr.
belated
on
stage,
a-
I have
on a
filed
query of
Toko's
the-
reply.
On a pointed query of the court, the learned counsel for the appellant has submitted that initially on receipt of the section 4 notice dated 9/11/2021, no Shoka's reply was filed. But after disposal, after passing of the
Impugn order. Impugn order.
order dated 15/5/2024, but is put in WPC 181 of 2024, a Shoka's reply has been submitted, but it is not annexed to this memo. Next paragraph. On a consideration of the materials available on record, and upon hearing the learned counsel for all sides, comma, this court is of the view that the court is of the view that insofar as the provisions of Arunachal Pradesh public premises within bracket eviction of unauthorized occupants bracket Act, 2003. There is a provision for appeal under section 12 thereof. Under section 12 within bracket 1 thereof, from every order passed by the state officer under section 5, 7 or 8, 7, 8 or 10 of the said act. Full stop. Therefore, there is no provision for an appeal to be entertained against Ashoka's notice issued under section 4 of the said act. Full stop. Therefore, comma, the appeal being otherwise not maintainable, notice issued under notwithstanding a file by the appellant before the Deputy Commissioner, East Siang District, such appeal is prima facie not maintainable. Stop. Resultantly, the Deputy Commissioner, East Siang District, will also have no jurisdiction to pass any interim order for staying the eviction process. Stop. Under such circumstances, now, this is only the observation made above is only an opinion of the court and not not a final verdict of the court in the matter, as the said issue is left open to be decided in the connected writ petition. Next paragraph. First off, this observation has been only made as because of the issue raised in the present appeal. First off, as a result of the privacy opinion formed by the court, the court is inclined to hold that the result of the prayer for interim relief by the learned single judge by the impugned order dated 15/5/2024, passed in WPC 181 of 2024, calls for no interference in this intra-court appeal. We respectfully endorse the view of the single judge that the impugned show cause notice was issued way back in the year, way back on 9/11/2021. Next view, we find no merit in this appeal and therefore the same is dismissed. Next paragraph, the court is inclined to clarify that the observations made in this order shall not prejudice the petitioner when the writ petition is heard on merit.
Your Lords, this is an IA for suspension of sentence of conviction, which I had prayed on the medical ground for the treatment of my father, who is suffering from health ailment, with kidney stone.
Documents?
Medical Doctors Board report is there at page number 12, annexure 1. It is in page 13. With reference to all statement, this shall patients, namely Sri Priyodivan, was examined by medical boards at General Hospital Konsa on 13/3/2024 at 1100. On examining the verification of medical reports, Sri Priyodivan 43 male is found to be suffering from bilateral renal calculi. He was also examined by the urologist at AMC Dibrugarh on 4th March and was advised for surgery. Endocristopropsy or open surgery. Endocytopropsy or open cristostomy. After that, I file and read, saying that at least he should be released on parole or give treatment as advised by the doctors.
No, you can still be operated upon, still in custody.
Yes,
Can be custody and-
what that also direction was issued in my writ petition, criminal writ petition 1, which I had annexed. It's
Huh.
page 15.
Yes. No, treatment you will be given.
Considering the, I will consider page 17, considering the fathers of the petitioner suffering from all ailment, it's required to undergo surgery as advised by the doctors, recommended by the board as constituted for the purpose. I deem it appropriate to dispose of this application with the direction to respondent to take a decision forthwith on the application. But
Because
till
if you have it done in the government hospital, then only it will be free. Otherwise, it will be, you will bear the cost. Cost can be defrayed by the government.
yes, even I am ready to incur the cost. Let him be taken to the hospital for
Definitely, they will take it. I think this orders, even the.
Lordship, may I, Lordship? Lordship, in this order, Lordship, may see, Lordship, this para 5, Lordship, wherein the state has communicated on dated 22/3/24, by which it has been informed by the authorities have sent a letter to the medical superintendent, General Hospital Konsa, for furnishing health status of the father of the petitioner convict, which is stated to be awaited, Lordship. So,
No,
Lordship,
please tell us. Can you understand from your submissions
Lordship,
that you don't want to give him treatment?
no,
The
Lordship.
state does not want to give treatment to the convict.
No, Lordship, it's
No.
not like that,
So you
Lordship.
see, we don't go by the contents of the order.
No,
Facts
sir.
may be different in every case. But if he is suffering from any ailment, it is
No, sir.
the government to give treatment to him.
Certainly,
Only-
Lordship.
There's only one factor. So far as we understand, we may be right or wrong, we don't know, but the consideration of the court is that if the government is making expenditure in its own hospital, it's otherwise free.
No, sir.
But if he goes for a treatment of a hospital of his choice, then he pays the bill. Correct.
No, sir.
And we are perhaps taking this view from the fact of that, what do you call that? What is, I forget the name. Mine is in clutter. That Edgar case of Kerala, what was that?
Sorry,
Urban
Lordship.
Urban Excel case. There, the Edgar a detainee, he was at his undertaking, he was kept in a, what you call, home confinement. And there was a expenditure bill of 1 crore rupees for maintaining his, what you call, home custody
Mhm.
at Gap. Correct.
I can't recall.
So Supreme Court said that yes, you have to pay.
No,
Once
sir.
you are, when it's an order of your choice. So therefore, same principle will apply. The state can't say that when, well, a person is suffering from kidney stone and we won't treat him.
Lordship, that is there.
So we have to allow this application if. Okay, you, what you call, where is your document? Where is your medical document?
It's page 12,
Hmm?
page 12,
Page
12 of my
12. We give you a notice, you verify it, within a week, we'll take it up.
Lordship,
On that day, we'll pass an order,
Lordship,
because you have to give you a notice of this interlocutory application. Had Mr. D.K. Deori London, counsel for the applicant, and Ms. Hela Akil London, additional PP, preparing for the state respondents, and Miss,
Legal aid counsel for respondent number 2, 3, and 4.
oh, okay, your name, please, again,
Sorry, Your Honor.
your name?
J. Doji. J.
J.
Adoji.
Doli. Learned,
I have not received this IA copy.
okay, please.
I'll serve him. The- the-
Learned legal aid counsel for respondent numbers 2, 3, and 4. Next paragraph. By referring to a medical board report dated 7/3/2024, within bracket annexure 1, because it is projected that the father of the applicant, Priyo, Dewan, DEWAN, who's the appellant in the connected criminal appeal 23 AP of 2023, was examined by the medical board and he was diagnosed of suffering from, inverted commas, bilateral, BILATERAL, next word is renal, RENAL, next word is calculi, CALCULI, inverted comma closed. On his examination conducted by urologist at AMC Dibrugarh on 4/3/2024, and he was advised for surgery within bracket endostylus or strictly ENDOCYSTOLIHOTRIPSY endostylotropy oblique open cytomy CYTOTOMY. Consequently, the medical board, after examining the father of the applicant on 7/3/2024, referred the admitted patient to undergo the surgery as advised above. Accordingly, next paragraph, accordingly, by filing this interlocutory application, the applicant is seeking a direction upon the he is praying for suspension of the sentence Next one. You should notice returnable in a week. First of the learned AP shall obtain information as to why the surgical treatment was not provided to the, no, as to whether any surgical intervention was provided to the convict CPU demand or not. She will also obtain information from the superintendent of the concerned jail where the said convict is presently lodged as to the place where he intends to have the surgery conducted. Full stop. Next paragraph. It would be permissible for the APP to send a download copies of the concerned superintendent of jail and obtain information. Next paragraph. List one. Give a date after a week.
Fifth June, can I?
Give a date after a week. Okay.
5th June.
6.
5th, can it be on 5th?
Huh?
5th.
5th is a hearing day. We are
Otherwise,
reserving those
11
days.
lawship, 11 June lawship.
4th June.
11 June lawship.
No, because if it's surgery,
4th
then
June.
calculate.
Your lordship, that is 4th June.
Fourth she will not be able to get it.
Counting lawship.
Okay,
Then she gets on
then 6 will be.
6, 3/20/24. Either 6 or 11, whatever is convenient to you. 6.
Otherwise, lawship.
What order is to pass in the appeal?
Appeal lawship.
Paper book already it's ordered. Paper book, but paper book is not ready. Paper book
It's not ready.
for paper book, it's already order is
The
there.
appeal, right? All sides are represented.
So this is 8/4. It's not ready. The order is there for paper. 7/12.
In your order dated 7/12/2020, comma, the registry shall expedite the preparation of paperwork. First one. List along with the connected interlocutory application on 6. 6/6/2024.
Otherwise, lawship.
I'm sorry, the records, it's in an e-file. They could not bring that. They have provided me only with the gradation list, e-file records. They said that they'll be sending it. Till now, I haven't received,
You can get it on the pen drive.
Yes,
It can
I
be-
have
it
asked
can
them
be-
to immediately
It can
send.
be brought in a passport protected and we'll look it here.
What they have in letter, they have stated that it's provision, but my lord. Door. In how this mentioned the arrangement indicated in the last column in the paragraphs comments for private respondents 2, 3, and 4 is purely provision and not final. The department is still in this context. There is a final and common seniority list of the year 2000, my lord.
Therefore, the department is being done as chalta hai.
In,
Nobody is bothered.
in fact, they are after let rules, my lord,
Everybody will be departmentally proceeded with.
my lord, therefore, my lord, what I will suggest, my lord may pass an order to file a detailed affidavit indicating the correct position, vacancy position.
No, no, not only that. Why leave it that? We said what do you call this, you see, you make a statement here in page 4, there is a final seniority list as on 2009.
Yes.
So where is this provisional one? You said
Provisional
it is provisional. Final can't be provisional.
This is what they have given, final seniority list. Thereafter, there are two more provisional seniority lists. What is the cadre strength? Cadre strength, my lord, 70, including one mechanical, my lord, excluding one mechanical.
Why this page 13 has 90 people named? If category 70, how it becomes 90?
It starts from the inception, my lord. Since in this, those who have already been promoted, their names are also there, my lord.
It can't happen.
My lord will kindly see serial number 1, 2, 3. One also is already promoted. Up to serial 17. There is another provisional. Well, promoted. These exercises are done in the lower level, and then it comes up. No. My lord, I will, my lord, it's very. That's why, my lord, what? Is my lord at serial number 80. I'm told he's out of station, my lord. It is the undersecretary who was conveying all this. In fact, the secretary is out of station. All these records were also sent by the undersecretary, my lord. Baru. Otherwise, my lord, what I pray, my lord, if my lord directs the department to file a concrete affidavit. Yes, my lord. Yes.
Your Lordship, if possible, the matter may be disposed of today, Your Lordship. Because we are here, Your Lordship, my
Received instruction. Actually, copy was attempted to serve to the detainee also. She refused also. And family call up the family, but they didn't turn up. There's a GD entry is there also, the last page also. Volume 11 also.
volume 12,
Volume also.
volume 12. Volume 12, page 155. 55. 155. Your Lordship. No, Your Lordship, such is because copy is not served to me.
Lost.
The service of notice will still not be proper because we have seen these photographs. You are merely saying that they are residing in the locality, but where is their house? In the house, you don't paste it. You go in the locality and paste it.
Also.
I'm just drawing a parallel because when I'm coming from the residence to the court,
No, sir.
road, there are so many posters affixed.
Correct.
I've never stopped to read a poster. So you see under the criminal code rules and orders of Guwahati High Court, I think this is applicable for the state of Arunachal also. You don't have a separate criminal code rules and orders for this state. Now, under this, you will find a chapter how this Latkajari is required to be done. It's criminal code rules and orders. Civil. Yes. Is that in? Yes, this is the chapter. Now, 4 is okay. Come to 5. Up to 4, no difficulty. Next 5.
5, Lordship.
Rule 5, huh? 1 to 4 is okay. 5, 6, 7, 8, then you will come to know. This is the manner of service of process.
Lordship, this part actually I understood, Lordship. This part,
So
Lordship.
this you have to
And
be
that
question.
was-
You
that
can't
was-
save your detention order.
That was not done, Lordship. See, refused, Lordship, so accordingly it was tested in that particular area, Lordship. Downwards.
Excuse me, your- So, yeah, ask it. Copy of the detention order was served. So, her sister was also part of it. This was the public, You see, in this GD entry,
Yes.
the last page, page 8, it is projected that the detention order was served on Lina Sora. Now, where is that acknowledgement?
Lordship. The last person, Lordship. The copy of the detention order was served to the Lena Sora, and her sister was also called to receive. Lordship. Lordship, that acknowledgement has not been. Lordship, actually, I think I have missed out to read out this lordship.
You see, there's there. That, in law, it was, I don't know, Newton's law. Every action has an opposite reaction. Third law of motion. Now, you see, what happens is that you serve it by in Assam language we call it latka jari. This process by pasting is a service. In my vocabulary, I say it latka jari because this is hanged. So now this hanging, if you say was done at a improper, was number one was done, then the question is that the police is aware of the alternate mode of the service of summons by way of hanging, correct? So if they are doing it, they must do it in a proper manner as prescribed. They can't now say that we don't know about the process. Otherwise, if they don't know about the process, they would not have known to hang it.
Correct, lordship.
So that's why
Lordship,
detention orders are
so
very,
for
very
this,
technical.
this particular lordship, the rule 4 is 5 is concerned, lordship. This pertaining to the lordship, the process by the criminal court, lordship. Though in particular this
No,
act,
no,
lordship,
no.
the principle
No,
has to be applied because serving of the lordship, the copy of the
No.
detention order with the documents.
Then perhaps you have missed
The
it.
principle has to be followed. That's correct, lordship.
No, no,
But
you perhaps you have missed it. I'll show it to you again. Please look at the heading.
Code of Criminal Procedure so and so, lordship, section 61.
No. Prior to that, there's a heading.
Service of process, lordship.
Prior to that, there's a heading.
Rules when under
No. In the top first line, heading,
which one?
heading. In the middle, there's a heading.
Rules made under, lordship.
Just show the another book. Give another book. No, give another copy. Give it this to him. Give us another copy. Give it. I'll just mark it and mark with pencil.
Rules made under X other than the Constitution of India, lordship.
So it covers all acts.
Lord.
Other than Constitution of India.
Here, lordship. Here, lordship. Then next, lordship, chapter 11, lordship. Chapter
No,
11.
No, you see the reason for that. In your code,
Lordship.
this particular act, what is that page? I'm not sure, 155. You see, in this Arunachal Pradesh Unlawful Activities Prevention Act, you don't have any format of service.
Yes.
So therefore, how will you do it? You take help of Criminal Procedure Code. You have got no alternative but to take the aid of Criminal Procedure
That's
Code.
why also I'm submitting, lordship. That this principle has to be followed. If
Yes.
lordship see the lordship, the past lordship, the section 61 lordship, it talks about the summon lordship. Summon is basically lordship processed by the court lordship. And if lordship is section 62, it talks about the service processes lawsuit.
Yes.
It's about the lawsuit, how someone has to be served lawsuit. This principle lawsuit has to be followed, that I understood law.
You're totally missing the point. In your act, read section 4. No, not this. This your
Laws.
UAP Act. Unlawful activities, 4(1). A detention order may be executed at any place in a state in a manner provided for execution of warrant of arrest under Code of Criminal Procedure.
Laws.
So this will apply in full vigore, proprio vigore.
Lawsuit.
I thought you were aware of this, that's why I jumped to that.
Lawsuit.
Hmm.
Here, here the education lawsuit. Education is the detention order lawsuit.
That's why 4(1) says it has to be done like that. This is summons, the warrant process is same. Warrant procedure exactly same. You turn one page more, you'll find warrant.
I may be wrong, say what I understood is, so far education is concerned. Education is lawsuit, the compliance of that detention order. That is the lawsuit detaining of that particular.
Correct.
Post detention lawsuit, there's another procedure lawsuit. The serving of the copy that comes into play lawsuit, is provided lawsuit.
No,
Within 5 days lawsuit copy
we
has
are
to be
unable
served.
follow you. We are unable to follow you. You see, when you make this GD entry, what do you say? When you are making the GD entry, what you are saying? A copy of the detention order was served on
No.
Lina Sora.
Laws.
Sister does not come, so you hang it.
Laws.
Therefore, this is an execution of process. The nomenclature may be a detention order, but it is a process you are serving. It's a detention order itself is a process. That's what section 4(1) says.
That part lawsuit, as I submitted lawsuit. Here lawsuit, chapter 11 is very specific laws. It talks about the summon lawsuit. Summon lawsuit and how the
Please turn
summon
the
has
page.
to be served lawsuit.
Please turn one page.
The
you'll
entire
find
procedure
warrant
has
also
been
is
laid
there.
down in this very chapter lawsuit.
Please turn the page, you'll find warrant also. Now, CRPC does not contain, Mr. Tapin, any provision for service of detention order. The execution of a detention order
Lawsuit.
is not prescribed in the Criminal Procedure Code. And your state legislature was aware of it. You can't say that the state legislature was not aware when they are writing in section 4(1) Criminal Procedure Code. That means any process with suitable modification as to form must be applied. Now I'll tell you, I'll explain you more.
Lawsuit,
You
I have already accepted. This principle has to be
No, no,
followed.
I'll explain to you more.
I have already accepted lawsuit.
No, I'll explain you more. There's some reason
But
for
what
it.
I'm pointing, literally lawsuit, language of the lawsuit is
No,
very
please bear
chapter.
with me. Please hold on for a moment.
No.
I will tell you something more. Now, under this Criminal Procedure Code, the manner of service is provided.
Correct.
We have Criminal Code rules and orders which prescribe the manner of service. We have in a High Court rules chapter for service of criminal process. Correct. I'll show you something. Yes, 235. Yes, 235, I flagged it. 235, I flagged it. Yes.
Yes.
Now you see, under the Guwahati High Court rules, this is the process form. The first process which I have shown you, you see, the service is through district magistrate, magistrate of district of so and so.
Correct.
Next, after the flag, no, same.
Yes.
After the flag, you'll find two, address two, TO2. That is addressed to the district magistrate. Correct.
Correct.
So therefore, under the Guwahati High Court rules, a process is required to be served through the district magistrate. Correct. But when we are issuing process under the criminal procedure code, this is not there. So the process is sent through the process server of the court or through the police station. Correct. Second is form number 2. Again, same district magistrate. Third, you see form to the district magistrate.
Right.
Now, what we are now doing is we are suitably modifying the form for effective service through the judicial magistrate or the CJM,
Yes.
because they have on their own process servers. So you see, although the rule provides to do in a particular manner, but we are not doing in that particular manner. What we are doing is, by judicially we are modifying the form and saying that let it be served through the SDGM or through the CJM. So that's what we are doing. So therefore, essentially what we are thinking aloud is that the legislature of the state was aware that the CRPC does not have a format for service of detention orders.
Correct.
And yet the legislature is saying that do it under the CRPC. We have to presume that the legislature does not use any word unnecessarily. It must have a meaning. Therefore, to give effect to the legislative intent, you will have to follow the process either of a summons or of a warrant. Otherwise, you don't have any other process. She is not a witness, so you can't send a process for appearance as a witness. Correct.
Correct.
So on service part, you can presume that we are well read.
Yeah, it's cool. Lordship. Here, Lordship, this petition was filed on 3/20, and immediately after post of filing of this, the petitioner was Lordship by revoking the Lordship detention order itself. Lordship is aware, Lordship, in the prevention law, Lordship. Twelve laws. One call was from Lordship, 10 Lordship.
Yes.
Lordship. It was 7.
Release on
Government order is 7/6 Lordship.
release on 9/6.
9/6 Lordship. So on this point, Lordship, as matter has been I have one submission, Lordship. Basically, this preventive detention law, no criminal proceeding, no proceeding is against that. The moment, Lordship, it's revoked, Lordship. Nothing remains, Lordship. No records, there's no sigma, Lordship. So matter comes to end here, Lordship. And therefore, Lordship, when it has been revoked already, exercising the section 14 of the Act, Lordship, then the matter has become infructuous, Lordship. Nothing is there, Lordship. And apart from that, Lordship, here, Lordship, what Lordship we are discussing, Lordship, that is regarding the Lordship whether this grounds of detention it was duly served or not, Lordship. On this point, just I'll place three judgment, Lordship, where it says, Lordship, when Lordship the legality of detention order itself is challenged, Lordship, then it has to be seen whether it's legal or illegal, Lordship. After, Lordship, the detention has been executed, Lordship, whether the procedure laid down has been followed or not, Lordship. That is only the post-detention procedure, Lordship. The moment, Lordship, the documents or Lordship, the detention order is not served, Lordship, the rights of the petitioner, Lordship, the detainee, Lordship, accrues, Lordship, and he can, Lordship, file approach the appropriate court for, Lordship, releasing, Lordship. In this judgment, Lordship, here regarding the Lordship, the sufficient copy was not furnished, Lordship. In this apex court held that, Lordship, the continued detention is not in terms of the Lordship less than procedure. Therefore, he is directed to be released, Lordship. In the present case also, because the legality of that detention order was not, Lordship, touched, Lordship, here, Here, Lordship, if the petitioner is insisting the legality of that, Lordship, detention order, Lordship, then, Lordship, we have to argue, Lordship. Only on the count, Lordship, because if I have read this petition lawsuit. Ground is lawsuit, that procedure has not been followed. That is the lawsuit that detention order was not served to the detainee lawsuit or her relatives. If that is the ground lawsuit, applying this lawsuit, law lawsuit, then he can be directed to be released lawsuit. He has now, as of now, he has been already released lawsuit. So therefore, what I'm submitting in the matter has become impactious lawsuit.
Yes. Your Lordship, my prayer is that because here two grounds. Only one is that I am not the participant, detainee is not the participant of the bond call, and neither participated in that particular 10 to 12. 12 is the last day of the bond call declared by some activists and arrested by the authority on 12. That is last day of bond call. After the arrest, the arresting authority neither communicates to the detainee for ground of arrest or her close relatives, Your Lordship. Never information never given. That is why, Lordship, because the detainee is deprived as per section 8 clause 1, Your Lordship. Merit. When a person is detained in the pursuing of the detention order, the authority making the order shall as soon as may be out of court, but ordinarily not later than 5 days and in exceptional circumstances and for reason to be recorded in the writing, not later than 10 days from the date of detention, communicate to him or his close relative the ground on which the order has been made, and shall afford him the earliest opportunity of making a representation against the order of the state government. So such changes is not opportunity given to the detainee, because the detention order is not served to the detainee. This is the ground that the detainee is not possible to give a representation to the government. Yes, as per article is 22 clause 5, Your Lordship. So on that ground, Your Lordship, may I given a citation, Your Lordship. This is the Consum Brojan Singh, Your Lordship. This is the Your Lordship, be the passed by this honorable court full bench, Your Lordship. The relevant portion is 57, Your Lordship. Para 57. Page 19, Your Lordship. May I read, Your Lordship? For all that aforesaid reason, we hold that the detainee that the detainee has to write under Article 222, Clause 5 of the Constitution 1 to be informed as soon as may be the ground on which the order of detention is passed. That is the ground on which lead to the subjective satisfaction of the authority. And to Clause 2, to be afforded the earliest opportunity of making a representation against the order of detention. The twin rights are available to the detainee, whether they are provided for or not in preventive detention law. Two, the right to make representation to the detaining authority by a detainee, in addition to this right, his right to file representation to the central government or appropriate government is also granted under Article 22, Clause 5 of the Constitution, which form part of package and guaranteed fundamental rights. Non-detention as such could be made in this regard in respect of the detention order made either under National Security Act so and so. The detaining authority is under the constitutional obligation to inform the detainee of his right to make such representation of the detaining authority. For the failure of information, detainees with such a right make representation to the detaining authority, vitiate the detention order make even under the provision of the National Security Act. This is the case here. Actually, here, Your Lordship, in this case, the detaining authority never informed to the detainee and his her close relatives, so that opportunity is not given her to represent to the state government. On that ground, Your Lordship, the detention order is declared illegal and set aside.
Lordship, may I-
Another citation is, Your Lordship, this is a apex court. Tushar Thakur versus Union India. Relevant portion is 14 years, para 14. So Your Lordship, this two citations, another two citations from the apex court, because the ground is that the detaining authority is not served the copy detention order and not communicate to the his or her close relatives. On that ground, the detention order is declared illegal and set aside. Thus, my prayer is that though the detainee is already released, Your Lordship, but the detention order is illegal because the detaining authority is not comply and not opportunity given to the detainee. That is why my prayer is that the detention order may be declared illegal and set aside. This is my prayer.
We pass orders in the chambers.
May I present this judgment also?
Ah, yes, why not?
Yeah, pass order. एक करके दे दो। ये भी ये भी तो कॉपी। हाँ, ये भी तो कॉपी। Lawsuit in 1982 SCC lawsuit. Paragraph 11 is relevant lawsuit. The first citation which I have placed lawsuit. Paragraph 11 lawsuit. Then 1984 SCC
If you're relying on this Ramchandra Kamath,
lawsuit. Kamat
I
case.
don't think this will help you because of the reason that a detention order is followed by by the requirement of providing of the grounds of arrest to the.
Correct lawsuit.
So here it's not the detention order, it's the ground of arrest. The Supreme Court saying in this case that once somebody asks for ground arrest, then you have to give him.
No. Here actually the grounds of detention that has to be furnished lawsuit. This provided under the act itself, and that was not furnished. The sufficient documents was not furnished lawsuit. Therefore, lawsuit that's amount to non-compliance of the lawsuit, that particular law lawsuit. Therefore, paragraph lawsuit 11 lawsuit. The detention order is not because on its own merit lawsuit, but the subsequent post-detention procedure has not been followed lawsuit, as grounds were not furnished lawsuit. Therefore, continued detention is illegal lawsuit. And in 1981, sorry, lawsuit, this issue Davis Cherarias case lawsuit. Paragraph
See para 6. Para 6 says, third line, in order to make an effective representation, the detainee is entitled to obtain information regarding the grounds of detention. When the grounds of detention are served on the detainee, he is entitled to ask for copies of the statements and documents referred to in so and so in the grounds of detention to enable him to make representation. Therefore, you see, in order to make everything, the detainee is entitled to obtain information relating to grounds of detention. So therefore, he can seek for grounds of detention. And when it is served, then he can ask for additional documents. This is the scheme under this Kofe-Posa.
Kofe-Posa case lawsuit. Under that act also lawsuit.
No, that's why we were referring to, when we are referring to Ramchandra Kamath,
Lawsuit.
then there's a procedure prescribed there. So that
In that Kofe-Posa act also lawsuit. The same procedure is a copy-paste lawsuit. This present law of our state lawsuit is more or less same lawsuit provision lawsuit. Here also lawsuit will find lawsuit. In this very present act also lawsuit. The grounds along with the documents has to be furnished lawsuit.
But here also grounds were not furnished, so he was released.
Correct lawsuit. The principle is a lawsuit. When the subsequent lawsuit, the post-detention procedure has, if not follow lawsuit in any manner lawsuit, then the continued detention is illegal. This is the principle lawsuit.
Correct.
Then lawsuit, other one is lawsuit, Ichu Davis case lawsuit. Ichu Davis here clearly lawsuit. Here also same thing lawsuit. Just I'd like to read lawsuit paragraph 11 lawsuit. It's very paragraph 11 lawsuit. This
11
is
of
1984 SCC 531 lawsuit.
watch, parallel.
Issue Davis, paragraph 11 lawsuit. This is at page 543 lawsuit. These were the reasons for which we allowed the writ petition and directed immediate release of the detainee from detention. We may point out that we have not pronounced upon the validity of the order of detention, but merely held the continued detentions of the detainee to be illegal on the ground of non-compliance with the requirement of clause 5 Article 22 and clause so and so of Section 3 of Copy Post Act. This is regarding the lawship, punishing of the grounds lawship. Article 22(5) also is talk about the grounds has to be punished laws. So therefore lawship, and other one also 1981 lawship, the same lawship. And moreover, lawship, just I wanted to point out one more thing, lawship. If lawship see the paragraph 23 of the petition lawship, this petition lawship. Here lawship, the petitioner has admitted lawship. May I read lawship, paragraph 23 lawship of the petition.
Paragraph.
Paragraph 23 lawship, it's at page 12 of the criminal petition lawship. The petitioner most humbly submits that from the date of her arrest till date, only the factum of detention order being passed against the detainee has been communicated to the family members. It's not that we are not communicated. It is humbly submitted that no communication has made to the detainee or her family member regarding the grounds on which the detention order was passed. And in the interpleadings lawsuit, the petitioner has never asked for grounds of detention or detention order lawsuit. There's no averment in this present petition if they have asked for the copy of the detention or the documents on which the detention is based on lawsuit. In the interpleadings, there's no averment if she had ever asked for the lawsuit grounds or detention order lawsuit. Though that doesn't absolve my lawsuit duty to punish. Yes.
He'll look into it personally, my lord. We'll file a detailed affidavit. In the meantime, we've also got the records e-file. Yes, madam.
If you come to page 6 of your affidavit.
You see,
Yes, madam.
this documents has reminded us of a very, I don't know whether I remember it right or wrong. It reminds me of a very old movie, Mr. India.
My lord, Mr.
Mr. India,
Okay.
Anil
Yes.
Kapoor. There was a villain there in that movie. And his pet slogan was, "मैं हंसू या रोऊं." So I'm reminded of that. I don't know why it came to my mind, but it just crossed my mind. Now my brother will explain you why.
My lord, this,
No, let me, my brother explain you why.
So, in the affidavit,
yes, madam.
we have seen how you have promoted this. Case.
Yes, madam.
Now, in the initial note that was there,
Yes, madam.
in the initial note that was there, these 3 persons were identified against 3 different persons.
This is from J to A, my lord. My lord will come,
Ad hoc appointment.
yes,
This is EE. So the vacancy that is being utilized is for AE.
Yes, my lord. When they were promoted in the year 2006
Huh.
from J to A.
Okay.
My lord will come to
6
internal
month-
page 12.
12. Huh.
12.
Hmm.
This is how they have worked out.
Okay. We got it. So when was this post by creation against Rupa Circle made?
This is as per that
When did you create this Rupa Circle
my
post?
lord, in the instruction, my lord, to 25/1/2011. My lord.
So why was that post lying vacant then all along? That might have filled up by someone.
25. Yes, my lord.
Right?
The department did not create post in
Yes,
2011.
Why was
Post
yes, my
someone,
lord.
to post someone now.
Yes,
It cannot be.
yes,
It cannot be a retrospective creation also.
yes, my lord.
So what is the benefit?
Yes.
Now you come to the next one.
Hmm.
Joba lawyer. Joba lawyer. I don't understand. What is that? It's an ad hoc.
Ad hoc. Yes, my lord.
So because of his death, this man is being put back there. And the post held by them is utilized.
Yes, my lord.
And that
That-
can be a regular post.
That's not a post.
Yes, my lord.
Now you come to Itum Naso.
Yes, my lord.
So now, as per this placement, we will understand Itum Naso to be the most. So, okay, fine. A promotion, assistant engineer, the next is executive engineer.
Executive.
Okay. On promotion of engineer, so and so as executive engineer.
Yes, my lord.
So this post, this vacant
This
post.
person also happens to be a direct recruitee.
Oh, fine. We'll not go into
Yes.
that. We'll not go into that.
Yes, my lord.
26/2012.
Yes.
Now, how can these two persons above him, without any post, be promoted from 2011? And the first post that admittedly from your affidavit, 2012. So this should be Moli Tatu,
Yes.
then Joya Lobar in another post, and whenever into Naso's turn comes, he will come in.
Yes, ma'am. Madam, therefore, this I have spoken to the secretary himself.
No, there's another.
Yes.
This documents you showed at page 15. This conveys different thing altogether.
And then come to your that letter, communication.
Yes, madam.
Now you come here. This is the provisional gradation list,
Page 15.
15,
Yes, ma'am.
right?
Yes, ma'am.
Now, where are those two persons now being considered? Is this three? Moli Tatu,
That's
Joya
number
Loba,
51, madam. 51,
serial
and
number 51.
51, 52, and 53.
Okay, 51, 52, and 53. You see their date of promotion. It
Madam.
is
Yes, my lord.
7/9/2020.
Yes, my lord. Here, that's why the private respondent, they file a writ challenging the recommendation of.
I know. When is this note? This
This
note
is
at page
after that.
12 and 13.
9. This is of DPC was held in 2020. Without giving them regularizing them from the date of DPC, which was put into challenge. In the
Now,
meantime,
you did not go back to the DPC.
no, my lord.
How can you do this without going back to the DPC?
This was in the meantime before the repetition
I
was.
got it. I got it, Mr. Vatam. Everything requires a DPC.
Yes, ma'am.
Now, see, you are utilizing something of 2011. You are literally, the departmental officials are doing a review of 2011 promotion, finding out a vacancy, putting them there.
Yes.
Without holding a DPC. How can you do that?
Yes, my lord.
The
Yes, sir. I
DPC,
understood.
as it's there, it's 2020. Now, if you have to change it, you will have to hold a review DPC. Without that, how can you?
Yes, my lord. Here, that's why the single judge direction was to give them retrospective regularization from the date of ad hoc promotion. Till that exercise has not been
Okay,
done.
I got it. The
In the
single
meantime,
judge's
this-
order is wrong. Let's hold it.
Yes,
It's wrong.
yes.
But you say that as per there is an order of my lord also in the compilation that it should be from the date when a vacancy was alive. Now the department can't determine that. The secretary cannot do it. It has to be by the DPC.
Yes, my lord. In the meantime, when this, we have not yet gone for the DPC also. Now, that's why our paragraph 6 says, my lord, in page 6, my lord, paragraph 17 says that we are going to conduct DPC and we are proposing to give them retrospective promotion from that day. That is the stand, my lord.
50-50. When was the rules? But what is the rules of which year?
2005, I believe.
5.
Yes. And
from the year 2010, and the new further segregated value groups as well as groups.
Yes.
May I please, Lordship?
Oh,
Lordship,
my lord, paragraph 17, my lord, I'll clarify that it is said that it's a proposal for giving them retrospective.
Fine.
Till date, we have not complied with the single judge order, my lord, single bench order.
Yes. Fine.
may I please, Lordship? Lordship, the government is saying that the DPC dated 31/12/2009. That is a final DPC, but I have an objection. Lordship, this is also a tentative common seniority list. As of now, the department has not prepared final seniority list. Here, in the memorandum, page number 169 of my writ appeal, it is clearly written that tentative common seniority list of assistant engineer under
Page
160.
169.
169.
169 of my writ appeal.
Tentative seniority list.
Yes, this is also a tentative seniority list.
Where are your names here?
Serial number 76, 77, 78.
2009. This is neither here nor there.
This is not the final seniority list.
Your grievance is that they cannot be given from the date before 2020. That's basically your grievance. And their case is that we are entitled from the day when the vacancies were there. They say from the date the ad hoc promotion was made. That can be Mr. Ratan's point of view that from the date the vacancies were available in the cadre. But first thing first, can you demonstrate now from the records that from 2005 onwards, what was the man in position and promoting direct recruit segregation in the cadre? That will bring to the forefront everything.
Lordship, if I may I take Lordship to page number 321.
No, we'll try to sort out things first. Number one, what is the man in position and what is the how this 50-50 ratio has been divided? How will we do that? Allow the respondents to do it. There'll be no clarity in the matter. Because ultimately, whatever decision is to be taken is by the government after the review DPC is done. Because they have created a mess in this matter. We are not finding any clarity to what you call, even to formulate as to how we proceed in the matter.
Yes,
Because you see, there are the orders which we may pass may have a ripple effect on the entire 70 people. Correct. Somebody may be placed in the rank of 5. He says that he should be at 4. So it will create a lot of administrative problems. So we propose that
My lord,
once
may I
we,
pray-
once we have expressed our thoughts to Mr. Ratan and he has communicated to the secretary, we think we should give them some time to
Come back.
breathe, take a decision and come back.
Yes, we'll file a detailed affidavit, my lord.
No, you see, the intention is not to have an affidavit on record. The intention is that you sort it out
Sort it out,
and
the entire thing. my lord.
then have it, and by the time you are filing an affidavit, you come out with we give you liberty, you come out with a draft gradation list,
Yes, my lord. Yes,
correct?
yes.
Absolutely. Mr. Ratan, the tentative provisional gradation list that you will prepare now will be as per their current situation, where they are.
Yes.
And thereafter, after doing that exercise, year-wise breakup, then you take a call that from when they would be entitled. Still, they cannot be promoted unless the whole matter is placed before the DPC. That the next stage we will see, but at least this much information you
In
place.
fact,
on
if,
record.
what I believe, what I've calculated, if 50-50 is, they fall even prior to that.
No, you see, the intention is different.
Private respondents at that point of time.
No, there will be two things. It's not the private respondents only. You will have to also factor in persons above them in the list in junior engineer.
Yes, Malad. That's why. Malad.
Say there may be a vacancy
Yes.
as of 2004.
Yes.
And they may be entitled.
Yes.
But above them, their seniority position in the junior engineer list may be 300.
Yes.
They are not entitled. The 299 might have gone by now.
There is no dispute that in the junior engineers, they were the senior most.
Okay.
So, in fact, there was a direct recruit in, which was, requisition was sent in the year 2009. Then it started, Malad. And then recruitment, direct recruitment made in that year also, Malad.
There's something wrong, because otherwise this mistake would not have happened.
And
Yes,
see,
Malad.
you
There
have
there is a total mess.
So you have placed in this provisional list direct recruitees of 12/4/2004 below promotee of 13/5/2004. Rightly so. But
Page
when I
15.
go down,
Page 15
page 15 of that letter,
of your,
Yes, Malad.
that compilation you have.
Yes, Malad.
If you come to serial number 25. Have you got it?
Yes, Malad.
Take Pusang, 13/5/2004. Then 12/4/2004 is a direct recruit. Again, 27, he is a direct recruit, right?
Yes.
Now you have again brought a promotee between. This promotee should go up. Because same year promotion, promotee will rank senior. Settle principle.
Yes, Malad.
So now you see, again you have put the direct recruits. Right?
Yes.
So
This
there is
has
no
to be-
application of mind.
Yes, Malad.
Only thing, Mr.
I will have to apprise them.
No.
No, you-
2005, what the situation is, how many promotees, how many direct recruits? 2007, starting how many did you fill up?
Yes, Malad.
8, 9, then if you make
Yes.
that exercise,
Yes,
everything is clear.
everything will be clear.
and
I have asked them.
there's one more aspect.
Yes.
You see, as my brother has already said, that this exercise of the past must be done by a review DPC. Correct. So, for the consumption of the code, for the perusal of the code, you also prepares a note that where according to your secretary, this placement should be altered.
Yes.
Position of the man in position would be altered. Correct. There is an exercise to be done by the DPC. That's one part. But the department takes a call that at least this is what they think should be the position of the man position,
Promotees.
promotees,
Yes.
specifically. Correct. So
Yes.
that is separate. Don't make it a part of the same chart.
Yes, ma'am.
You make a separate chart for the purpose of the understanding of the court.
Yes.
And normally, you know, this is the basis of the agenda notice, agenda notice. So form of agenda notice, they can place it.
When you send the matter to a DPC, I don't know what it is called here. Normally, it's called an agenda note,
Yes.
where everything is given, and then the ACRs, FCRs and sent. An agenda note in that tentative one can also be placed along with your,
Yes.
after this exercise is complete. I think that'll,
Yes, my lord. After doing all this exercise, we'll file an affidavit, my lord.
right, fine. We'll have to provide. Mr.
Till then, lordship, my prayer.
They cannot be, because they have not even taken a decision to that.
Yes.
This is all tentative. They continue to where they are. Mr. N. Ratan Lanan, Additional Advocate General, in terms of the undertaking made by him on the last date of listing, has to today placed before the court a written communication received by him from the Undersecretary PHE and WSD Department, wherein it has been stated that the proposal for conducting DPC for grant of retrospective promotion to the private respondents number 2, 3, and 4 herein is being so contemplated from the date of availability of promotional vacancies against the promotional quota in the cadre of assistant engineer of the service. Full stop. Mr. Full stop. Okay. Full stop. Perusal of the affidavits filed in the matter by the respondent authorities also reveal that certain vacancies were identified for the purpose of granting retrospective promotion to the respondents number 2, 3, and 4. Full stop. The communication as brought on record has also as its enclosure a provisional seniority list of assistant engineers under the department as on December 2022, and therein we find that the placement of the persons, both promotees and direct recruits of the same year, have not been made by adopting a particular yardstick. And with regard to the promotees and direct recruits, we find different yardsticks being applied in respect of the different incumbents in the cadre. Insofar as the respondents number 2, 3, and 4, they have been shown as promotees, and their date of entry into the cadre on promotion basis has been shown to be on 7/9/2020. Full stop. When the infirmities as coming to notice while considering the matters, also the note sheets as produced before us, Mr. N. Ratan, learned Additional Advocate General appearing for the state respondents, has fairly submitted that the matter requires a detailed examination by the authority concerned, and accordingly, he has informed that the Secretary of the Department would now, under his initiative, carry out a detailed review of the cadre, and after determining the man in position with effect from 2005, and thereafter finding out the ratio, by finding out the persons joining the cadre on promotion basis and on direct recruitment basis, shall work out the from 2005 till the year 2020-23, shall work out the excess appointees of either of the stream and then calculate the number of promotees who would calculate the vacancies that would now be available at the earliest point of time for accommodation of the promotees. Mr. Ratan has also submitted that after the conclusion of the said exercise, an agenda note, tentative agenda note would also be prepared, wherein the case of persons like the respondents number 2, 3, and 4 who are claiming retrospective effect to their promotion to the cadre of assistant engineer shall be now indicated from when such promotions at the earliest can be considered. Full stop. Mr. Ratan has also undertaken that the matter would now not be placed before the DPC and it would be considered for such placement after the said exercise is carried out and an affidavit incorporating the same is placed for perusal by this court. Full stop. In view of the above position and the exercise exercise to be carried out by in terms of the undertaking given above, which would require a considerable period of time. This court is of the view that the matter be listed again after 6 weeks. On a date to be fixed by the registry. However, it is clarified, it is provided that the affidavit in question must invariably be filed in the manner undertaken to be, in the manner as undertaken above, in the manner as undertaken by the learned additional advocate general. It is also provided that the affidavit that would now be shown after the said exercise, incorporating the results of the said exercise, must be shown by an authority not below the rank of secretary of the department. List this matter, raise you to list this matter again after 6 weeks on a date to be fixed by it.
Obliged, madam. Let them sort out. Now they will sort out. Yes, madam.
Simple thing, break up that, everything will be clear. Once we do that for them, there will be many.
Yes.
And Parmar is no longer there. So there, that exercise is also not there.
Madam, regarding Parmar, madam, in another case, madam, I have found out, madam, in 2023 judgment.
Rajesh Kumar,
No,
State of
in
Himachal Pradesh.
Hiralal. Here again, Parmar has been
held to be a bed law.
again here it has been held,
Rajesh, State of HP versus Rajesh Kumar.
it has been held here again.
No, this is 22, that is 23.
This is 23.
This is 22, 22, 14, 10, 12, 22. The other judgment, Rajesh, it's 23.
Here again, it has been sent to the larger bench.
And see, Parmar will not apply in your case. Because if you read Parmar, towards the bottom, there are 2 judgments reflect, where Parmar is again on the OMs of the Government of India. Where there is a service rule, Parmar has got no application. My view.
In our state, we apply the central service rules.
No, you have a service rule, Parmar will have got no application. That is on the basis of the notifications. That judgment, if you read towards the bottom, you'll find one Orissa and one somewhere.
Obliged, madam.
I have taken the consent.
Okay. Both sides are represented. Just on when?
5th of June.
In 5/6/2024, as paid for by Mr. K. Saxena, counsel for the petitioner.
May I hold the chief? I would like to mention item number 33. The learned counsel is out of station.
Which item?
33.
36,
33.
33.
Yes, Your Honor. And I have already taken the consent from the other party. Matter may be fixed after 4 weeks.
Such a representative on the prayer made by counsel for the appellant. Matter stands adjourned today. List after a week. Yes.
Much obliged.
Lordship, may I beg to mention item number 31, that hearing matter, that may be fixed after 3 weeks. This matter is represented by this audit lawyer.
Okay, you have informed the other side.
Yes, inform the others.
Okay. It says a representative. List after 3 weeks is paid for by the counsel for the appellant.
My lord, I may be allowed to mention item 5.
Yes.
We have taken the consent from the other side.
Just a moment, there's something here. Item 5. Who's for the other side? Who's for the other side? No one is there. Okay, list after
3 weeks.
3 weeks as paid for by the counsel for the petitioner.
Yes.
May Lordship, I would like to mention item number 2324, Lordship. Lordship, this matter may be listed on 5th, Lordship, next week, Lordship, on 5th, Lordship. I'm taking the consent from other side.
Okay. List after a week as paid for by the counsel for the
On 5th, Lordship.
petitioner.
Yes, Lordship.
You have a petitioner?
Yes, Lordship, I'm on the petitioner.
Okay.
Entry may be continued, Lordship.
Hmm?
Entry may be continued.
Interim order
Item
for
number
petitioner is
24.
extended to the next date of listing.
And Lordship, 2 more, Lordship. Item number 8 and 9, Lordship. I may be allowed to withdraw, Lordship, on instructions of the petitioner, Lordship. I may be allowed to withdraw, Lordship.
All sides are represented. Upon instructions, Mr. G. Bam, learned counsel for the petitioner, seeks to withdraw this writ petition. Where is allowed, the matter stands dismissed on withdrawal.
Right, yes, Lordship. Lordship, I beg to mention item number 30 on behalf of OPATA. Leading counsel OPATA is out of station, Lordship. The matter may be listed after 2 weeks.
Okay. List after 2 weeks is paid for by the counsel for the private respondent.
One more item, Lordship. Item number 17, Lordship. Service report to respondent number 8 is still awaited, Lordship. The matter may be fixed after 2 weeks, Lordship. On
Just
behalf
wait,
of
let the
the
matter be called. You wait, in this matter will pass orders and then please wait till the matter is called.
Obliged.
Item number 1.
May I please, madam? Presents a contempt petition, Lord. Earlier, petitioner approached this honorable court, being aggrieved by non-inclusion of his name in a
So the
seniority
date of
list.
the order,
Order is, my lord, lecture 1, at the page number 9.
just tell us the date,
Date of judgment.
date of order, yes,
Order is 12/4/2024.
contempt.
Yes.
Mr. D. Lazo, counsel for the petitioner. Contempt, order date 12/4/2024. Notice takes steps within 2 days. Pendency of the contempt petition shall not be barred for compliance with the order of the court. Give a date after 5 weeks. After 15 July.
15 July. Most likely.
Item number 2.
What is the document from which you are saying that it's a private line?
My lord, madam, page number 157, my lord.
157.
My lord. 157.
Yes.
57, my lord. It is not only 157, 58, 59, series of certificates of various citizenship, my lord. Issued by the village authorities, my lord. And actually, my
No, but
lord,
this
it
is reserve forest.
No, not reserve forest, my lord. It is private reserve forest, my lord. Not government reserve forest. We have this different in this our this area, private land, my lord. We have different categories of land, private land, my lord. Some are private reserve land that we use in times in any appropriate mode, my lord, of cultivation, my lord. We use them. For that, we reserve land for ourselves, and it's been kept under our control and possession.
Shows any authority on the point that this is the law of the land. But if it's a reserve forest, it's normally expected. It's a government.
No, my lord, it's actually not government reserve forest, my lord. It's not government reserve forest.
Yes.
It's private reserve forest, my lord.
According to the sanction order, madam, it's reserve, comes under reserve forest, madam.
Pardon me?
It comes under reserve forest, madam, according to our sanction order, madam.
No, but do you admit that there is a private reserve forest also in the state?
No, madam. I have to take instruction on that, madam.
You have to show us, otherwise we can't issue a notice. You have to show us that this reserve forest is a private reserve forest. There must be some document to show that it's a private land. You should have a land holding. You should have the land declared as a community
No,
land.
generally, my lord, in tribal areas, in Arunachal Pradesh, my lord, it is the one option is there, the land position certificate, my lord. Another option is the one I have placed before your lordship, village authorities certificate, my lord.
Oh, village authority in the morning, they will give another certificate, in the evening, they will get another certificate.
No, only for their village, my lord.
No, you see, under some act, you see, please tell us, what do you mean by a certificate?
Well,
What do you understand, or what should we understand? What is a certificate?
No, it is in our humble understanding, my lord, it is an declaration given by a competent authority, my lord, giving this some assertion or right on the party person.
Okay, let me ask you that I go to a village authority. I'm a resident of a particular village.
Fine.
I go to the village authority
Fine.
and I request them, please give me a certificate that I am MSc. I'm a master degree holder in science.
No, my lord. That they cannot give, my lord.
They cannot give.
No.
So therefore, what is the law which permits them to give a certificate?
No, my lord, actually, in our system, my lord.
No, system is something.
There is nothing written like.
Mr. Jamo, you see, if somebody gives a certificate,
Right.
he must have an authority to do so.
My lord.
And what we understand, that if there is a public record,
Right.
then one can issue a certificate, because you see the land revenue authorities, there's an LPC given to you. So therefore, on that basis, they give a certificate that X has a land, what do you call, land LPC under number 1 dated 1/1/11, correct? So a certificate must reflect some evidence of the original document being available. But if a village authority starts giving a certificate, then you must also demonstrate that they have a power to do so.
My lord.
Anybody, if there's a very happy Gamura, he'll give all sort of certificate.
My lord, actually, such particularly, those practices are not actually,
Then we can't issue,
please come to the lower portion, declaration portion, my lord. May I read?
by knowledge.
My lord, knowledge.
You see, when I go outside
My,
this corridor, there's a very beautiful hill.
my lord.
I think that belongs to Mr. Majumdar. I can see him here. Correct. As per my knowledge, my understanding, and having once seen some similarity of his face on the hilltop, I give a certificate that yes, this hill belongs to Mr. Majumdar.
At least the example of Mr. Mazumdar, one could know is false. But had it been the case of Mr. Tara, one same thing happened with me. I looked at the hill and said, it is beautiful. And he told me the hill belongs to him.
My lord, it is written, my lord. This certificate
So I take back my example and I give it, I put it on Mr. Jamo. I put it on Mr. Jamo.
And that hill was overlooking his house. And his house itself was on top of the hill. And he said that hill also belongs to him.
Good.
Your lordship.
No, we have too many happy people giving certificates.
On the certificate.
If there's no private reserve forest, we dismissing your petition.
My lord, it will be very dangerous for us, my lord, for our livelihood, my lord. Generally,
You please explain it to us, because this is a concept I don't know.
my lord,
We have seen in Godavarman.
my lord.
After Godavarman, the concept of a reserve forest we've understood. Now, if you want anything contrary to be understood by us, you'll have to show us an authority better than T.N. Godavarman.
No, your lordship, please come to the this certificate part, my lord. It is written, this certificate is issued premise on the proper knowledge and recognition of the villagers of their village, my lord, to his tribal land ownership right, since there is no land record maintained for tribal private land in Arunachal Pradesh, my lord. So it is clearly written here, my lord.
No, why you are getting the document from them? You could have got it from the government authorities. They're not satisfied. We'll pose a question, you show us something more. Instead of dismissing it, we give you some time. But Mr. T. Jamu, counsel for the.
My lord. Then, instead of dismissing, my lord.
No, I'm not dismissing. I'm giving you an opportunity of giving us better particulars. You're not dismissing it. Once you said that there will be dangerous, so.
No, it will surely, my lord, because not only me,
It's
I'm
okay,
making
we are
the assumption
accepting it.
before this bar, my
We are
lord.
accepting it.
90% of the people of Arunachal Pradesh, tribal people, doesn't have that paper, my lord. That I am making this submission before the whole bar, my lord. If such things are not, I am submitting this before you, lord. There are two options here in Arunachal Pradesh, in practice, my lord. First is land position certificate. Land position, and the land position certificate, to obtain a land position certificate is well nigh impossible for a villager, my lord. It is very tedious.
Can't accept.
Yes.
Can't accept, because otherwise they would have been knowing people of Arunachal Pradesh.
My lord.
or say semblance of knowing the people of unanswerable, they would have protested. If it is difficult, it's not very difficult. It is difficult only when you don't have the ownership and then you try to claim that this hill is mine. This
No,
forest
no,
is mine.
that is not done, my lord. That,
Otherwise-
under the circumstances, this certificate would never have been come, my lord.
Oh, it comes. You go to a Gambura, this Gambura again,
My lord.
you ask for a what you call skin color certificate of Michael Jackson, and you find it, he'll give it to you. You show him you sing before him the song, black or white, and ask him from a certificate, he will give it.
Okay,
Certificates are easy, but certificate must have some backing. We are not satisfied. But Mr. T. Jamotan, counsel for the petitioners, and Mr. T. Wango, the rest,
1 to
government
5
advocate
months.
appearing for the respondents.
1 to 5 months.
1 to
5.
5.
Others are private respondent.
Okay. 1 to 5. Next para. To project that the land on which afforestation under Campa scheme is being undertaken is a private land. The London Council for the petitioner has relied on a certificate within bracket page 157. First one. The court is disinclined to accept the certificate given by the head Gambura regarding ownership of the land, because in the opinion of the court, a certificate must reflect the availability of certain government document to justify the contents of the certificate. Next paragraph. Although the learned counsel for the petitioners has submitted that in the village areas, people may not have land documents and no land records are available. In that event, to accept a certificate to be the proof of land holding is not found to be acceptable. Next, but according to the learned counsel for the petitioner is permitted to supplement this repetition with better particulars. List after a week.
Well,
List after
3 weeks, my lord. It is it will be in that circumstances, my lord. It will be a very tedious job for me again, my lord.
list after 3 weeks in the motion column.
My lord, the 4 petitioners collectively are challenging the orders of the disqualification. Lordship may go through the. So, my lord, these 4 petitioners.
We are in the age of multitasking. We are in the age of multitasking.
True, my lord, but sometimes, my lord, one may tend to feel that possibly my lord is reading, so I should not be disturbing.
No.
Very well. So, my lord, it is the order of their disqualification which is under challenge as Jilla Parishad members. The petitioners are 4 in numbers. Now, my lord, by now, my lord, yesterday also there was a matter like this. Under section 3, there are 2 parameters which may attract a disqualification. Number 1, voluntary resignation from a party. Number 2, the next one, my lord, is not attracted, abstaining from voting, etc., etc. That is not attracted in the present case. Now, here, my lord, one may try to make out a case of voluntary resignation from a party, coupled with expulsion. Now, my lord, both the factors will be very relevant. And what is required to be seen is whether the present case is a case where even prima facie, a case of voluntary resignation from a party is made out so as to attack disqualification, number one, and number two, whether their expulsion from the BJP would attract disqualification. Expulsion simpliciter would attract disqualification. No, both the factors have to be looked into in the present case. I'll just not give the sequence of events which are very relevant, because ultimately it is their conduct which is under scrutiny. From the conduct, it is to be ascertained as to whether or not one may prima facie come to conclusion that they had voluntarily resigned from a party. Of course, my lord, there is another facet to this case. I will come to that facet later. First of all, I will address my lord on the first count. Now, my lord, Annexure P1 Collie is a certificate of election. From certificate of election, my lord will find that, my lord, they are all from 2020. In 2020, they were elected as ZPMs. So the tenure is 5 years under section 86. So therefore, my lord, their 5 years will be completed only in the year 2025. The next is, my lord, the notification. The notification is 23rd February 2024, page 30, creating K Penure district. How could you await pages?
Those are.
My lord, it has some significance. I will come to that later. Now, my lord, only lordship somewhere at the back of the mind will take note of the date, 23rd February 2024, a new district was created. This district was carved out of undivided Lower Subansiri. These Jila Parishad members, my lord, are from the district Lower Subansiri. My lord, I also clarify another thing. In Lower Subansiri, undivided Lower Subansiri, before carving out of K Penure district, there were total 20 Jila Parishad members. Out of the 20 Jila Parishad members, the 6 Jila Parishad members, their constituencies became part of the newly created K Penure district. Out of the 6 Jila Parishad members, these 4, my lord, also belong to the category of 6. So 6 include these 4. Possibly, my lord, 23rd February 2024 was a trigger. It was a trigger because, my lord, will see the letter of 28th March 2024, page 31. Page 31, my lord, the 4 Jila Parishad members along with 1/5 independent, they wrote a letter to district president of Bharatiya Janata Party, K Penure district, Yachuli, because by now the new district had come. So they addressed their letter to the president of the new district. It is respectfully informed to bring to your notice that we, the undersigned, 5 ZPMs, including the present JPC, out of the 6 Jila Parishad members of K Penure district, Jila Parishad do hereby merge to NCP Ajit Pawar with more than 2/3 majority. Because the impression is maybe they felt since new district has come, now they belong to the new district. In new district, even though the Jila Parishad formally has not been constituted, it has to be constituted as per the mandate of section 85, as and when it is created, because they are the current Jila Parishad members. Presently, there are only 6 in the K Penure. Out of the 6 below, these 5 will constitute more than 2/3. So that is how they proceeded. Be that as it may, my lord will see annexure P3 on the same date, 5 days later, on the same date, page 32. They also wrote a letter to Deputy Commissioner and Member Secretary of a new district. Page 32, the next page. It is to respectfully inform and to bring to your notice that we, the undersigned, 5 Jila Parishad members, including the present below, same contents, verbatim similar, declaring that we are the 5 out of the 6 and we constitute more than 2/3 and we intend to merge with NCP Ajit Pawar. So, my lord, there is an expression of intention to merge. I'll put it this way. A declaration of intent to merge with a new political party. Then comes, my lord, 29th March, immediately the next date. On 28th March, these letters were issued. The very next day, on 29th March, the state president of Bharatiya Janata Party issued a show cause. Now, my lord, one more thing I clarify. it is very important. Along with the declaration of their intention to merge with a new political party in a new district, they also resigned from the Bharatiya Janata Party. It is correct. They resigned from the Bharatiya Janata Party. The letter of resignation was not handed over. It could not be annexed. But I admit the fact that they also resigned. But while admitting the fact that they also resigned from the party, it is equally correct that their resignation was not accepted by the party. Instead, my lord, the party issued a show cause notice at page 33, initiating expulsion proceeding. This is with reference to written complaint. The contents of the letter are, the show cause notice are, this is with reference to written complaint and the representations received by the party office about your alleged misconduct, non-adherence and non-compliance to the direction, notification and circular issued in interest of the party. Furthermore, allegations that you are indulging into anti-party activities for your self-vested interest. Our party believes in observing high ethical values in all respect and expect the same from all its party members, leading to healthy organizational environment. Undersigned has taken a serious note of the same and hereby condemn the same and issue show cause notice to allow you to put forth your explanation. You are hereby directed to submit a written explanation of your conduct within a period of such and such, such and such. So, my lord may be pleased to appreciate the fact that the show cause notice of 29th March 2024 does not specify anything. It uses vague expressions like anti-party activities, non-adherence, non-compliance, etc., etc. I would presume that my expression of intention to merge with another political party was a trigger towards issuance of this show cause notice. There was nothing more, there was nothing less. There were only two factors. Number one, my resignation from BJP, and number two, my declaration of intent to merge with another political party. That was a trigger for the show cause notice. There was nothing more than that. We proceed further. My lord, it is our case that this show cause notice of 29th March never received by us on time. A week later, formal orders of expulsion were issued from the party. We were expelled for 6 years. The order of expulsion is 7th April 2024.
You'll also have to use your excellent skills to again read this page 31. We, the undersigned, so and so, do hereby merge.
My lord,
Once it is merged,
my lord,
how is can be read as
my lord,
intent to merge?
my lord, for the simple reason, the merger is not a unilateral act. Unilaterally, one cannot merge. There has to be, my lord, the equal expression of intent by NCP Ajit Pawar. My intention to merge with another political party has to be acknowledged and accepted by the other political party with which I am going to merge. So, my lord, one may not go by the exact expression, because English, my lord, after all, is a foreign language for all these people. Even the lawyers, the way they write these days, my lord, leave that aside. But, my lord,
For you,
my lord,
foreign language.
my lord,
I was expecting that question from the sound report.
my lord, but legal position is this, which is also a factual position, that merger is not a unilateral action. There can never be a unilateral act of merger, which my esteemed colleague also cannot deny. Merger, my lord, there has to be an action from two different sides. I will declare that I am going to merge, I write to you, you accept it. There is no acceptance of such a merger by NCP Ajit Pawar. But, my lord, that by itself will not possibly condone my action. This is not enough. I also make it very clear, and there is a specific pleading in the writ petition, that we will be assailing our order of expulsion, may not before a competent court. That will be a civil court, of course. That is a different issue altogether. But there is more to it now. So, my lord, I was on page 32. So, my lord, I submit, it is an intention to merge, because act of merger was not complete. It is not an action from my side alone, which will culminate into the factum of merger. It is not enough. So, my lord, the next is the 7th April, my lord, has seen expulsion is there. So, my lord, three things have happened by now. Number one, intention to merge. Coupled with my resignation from BJP, followed by expulsion. Expulsion is complete. I am out of the party. Page 34 onwards, 4 orders of expulsion. Now, my lord, what happened thereafter? Page 38. Immediately, my lord, on the very day, order of expulsion was issued. The Bharatiya Janata Party.
There's something I wanted to show you. Just
My
a
lord.
moment. Just.
Here's the key 8. Basic mistakes. I'm expecting something very, very interesting from my lordship.
No,
I'm
no.
waiting with bated.
No, it is not interesting, but I'm trying to make it interesting.
Very good. But I hope, my lord, my point, lordship will be able to appreciate. Merger is not a unilateral action.
No, but since something is in mind,
Very well.
my that multitasking has stopped for a moment.
Very well.
So
Very well.
therefore,
In this case also there was newspaper reports.
no.
Something more.
I hardly spent time to read this. This minutes.
Ah,
Maybe Mr. Malda would like to join you. So you'll have to read this adversely.
my lord has shown it to me.
No,
It's for my,
accept that he can also join.
it's for my perusal.
No, you see, here is a case where you see, I read it reversely in your case. There's a hammer, and Dennis is explaining to Joy that this hammer is used by some people to mend things, but this can also be used to break things.
Correct.
Now you read it adversely.
Yeah.
Some people have already broken something,
Yes.
and then they are using the handle to mend it.
I was anticipating this and I'm prepared for this. I accept it. And my lord, precisely that will be my case. I will accept this very argument and I will proceed with this argument and I will test this argument
Okay.
on the facts of the present case.
Okay.
I admit, my lord, the fact of the matter is, my lord, in this writ petition, there is no letter of resignation. I made a personal inquiry. I found out there is a letter of resignation. And my lord, I have admitted before your lordship, they resigned also from the party. Their action was complete. They resigned. They issued a letter expressing the intention to merge. But factum of merger was not complete because there was no reciprocation of the same by the other party. But fact of the matter is, show cause notice issued immediately the very next day, alleging anti-party activities, presumably anti-party activities, by anti-party activities, the BJP meant their conduct of expressing the intent to merge with another political party. And also the resignation. Resignation was not accepted. Had it been accepted, my lord, there would have been no occasion. There would have been no occasion to initiate expulsion proceeding from the BJP. I asked myself.
Can I ask you a question? You see, A is accused of some disciplinary action against him he has defalcated money or he may have done some mischief. So he knows that tomorrow he'll be suspended. Now, let us say he resigns from service. Now, is the employer debarred from rejecting the resignation and suspend him, initiate departmental proceeding against him?
The answer is very simple. If the employer wants to punish him, the employer would not confine himself to accept the resignation. Employer would say, no, I am not accepting your resignation. I would rather punish you. The conduct of BJP to initiate expulsion proceeding against these very people with the primary was for the primary intention of punishing them. So, my lord, but the fact of the matter is, resignation is there. Resignation was not accepted. On the contrary, for so-called anti-party activities, so-called because they did not specify, but I would presume it is an expression of intent to merge. That was the anti-party activity. Show cause notice was issued. Show cause notice culminated into expulsion proceeding. Now, my lord, expulsion proceeding, the legality of it can't be the subject matter of challenge before the honorable court. But, my lord, this is a relevant fact which has to be taken into consideration primarily for the purpose of judging the merit of disqualification, which is an issue before the honorable court. Now, my lord, what happens thereafter? So, 7th of April 2024 is the letter of the BJP to the member secretary Jilla Parishad Lower Subansiri. Again, my lord, if we go by the mandate of law, one would argue, and I will not be going for the technical argument, one may argue that the member secretary is a competent authority to forward the request for beginning the disqualification proceeding to the deputy commissioner. Since it is a different district, it ought to have been the member secretary of Kai Penyor. I will not go for the technical argument because one may say counter argument will be there is no constitution of Jilla Parishad in the Kai Penyor. So where would be the member secretary? It is undivided Lower Subansiri, divided yes, but undivided Jilla Parishad. And the member secretaries of Lower Subansiri. So we will not leave that technical argument aside. So letter written to member secretary Jilla Parishad Lower Subansiri. Now, my lord, contents of the letter of the BJP, page 38. I read that. It is pertinent to mention here. 1, 2, 3, the third paragraph, the last paragraph, my lord, of page 38. Last paragraph of page 38. It is pertinent to mention here that even though Kai Penyor district has been notified recently by the government of Arunachal Pradesh, but delimitation process had not been initiated regarding the Jilla Parishad constituencies. The concerned Jilla Parishad is still the Jilla Parishad of Lower Subansiri district, and the ZPMs are also still members of Jilla Parishad constituency of Lower Subansiri district. Therefore, considering the total seats of Jilla Parishad members in Lower Subansiri district, their merger does not have the merit required in terms of numbers stroke quorum to claim immunity from disqualification. Further, it is submitted that there is no provision for members in the relevant laws for merger by claiming 2/3 majority. Then, my lord, the page 39, the second paragraph. The second, page 39, the second paragraph, the expelled members have not submitted any letter or intimation regarding any withdrawal of merger to NCP Ajit Pawar, either before the office of the district president of the concerned district, nor before the chairman SDAC BJP or Arunachal Pradesh till date. It is made absolutely clear that there is no revocation order in respect of the expulsion made against the said expelled members on 7/4/24, nor any pending proceeding for consideration of revocation before the State Disciplinary Action Committee as on party record till date. Therefore, it is reiterated that the expulsion order dated 7/4/24 stands, and the expelled members are no longer members of BJP. Their disqualification should be a watermark, mark example against unethical practice of politics in the state of Arunachal Pradesh. It must serve as a stern warning across all party lines that law of the land shall not allow trampling of the cherished democratic process. Your kind chair is prayed to immediately disqualify the defectors under relevant provisions of Local Authorities Prohibition of Defection Act 2003, such and such. Therefore, all the members must be disqualified immediately without any delay, and the concerned Jilla constituencies must be declared vacant for henceforth. Any delay in disqualification of the above expelled members shall be regretted, such and such. So, my lord, contents contents make it very, very clear. It is the expulsion alone for the BJP. Resignation is simply not being taken into account at all. BJP has ignored the resignation part. BJP said we have expelled them. They are not the members of the party. Plea of 2/3 majority will not stand. There is no new Jila Parishad in the new district. It will not stand scrutiny. Initiate disqualification proceeding so far as they are concerned. So it is, my lord, the expulsion. Then 8th April 2024, page 40. It is, my lord, the state president of the BJP writing to Secretary State Commission. Details are given, not very relevant for our case. All the 4 names figure here in the chart. It is the intimation. Now, my lord, 9th April 24, page 41, the Secretary, State Election Commission forwarded the letter of the BJP for initiation of disqualification proceeding to Deputy Commissioner Lord Subansiri. He was wearing 2 hats, both of K. Tenure and Lord Subansiri. The letter was forwarded to him to initiate the disqualification proceeding. 9th April 24 is the date. The very next day, my lord, on 10th of April 24, at page 42, the show cause notice was issued by the Deputy Commissioner. 10th April 24. 6 days later, on 16th April 24, at page 43, these petitioners, they write to Deputy Commissioner saying that they have not received the details, etc., asking for details of the complaint. My lord, but one more thing is important. So far as show cause notice is concerned, my lord, may kindly take note of the fact that in the show cause notice of Deputy Commissioner of Lower Subansiri District dated 10th April 2024, it is expulsion is specifically mentioned. There is no talk of resignation anywhere. Even Deputy Commissioner, my lord, is taking note of the expulsion alone. Para number 2, my lord, of the show cause notice. And whereas the state president in charge come chairman State Disciplinary Action Committee BJP Arunachal Pradesh wide letter number such and such had intimated regarding your expulsion from Bharatiya Janata Party and prayed for disqualification thereof under the relevant laws. In view of the above facts and circumstances, you are hereby directed to show cause. So basically, my lord, the trigger is the expulsion. Resignation is nowhere in the picture. Page 43, we ask for details, etc., The next page is very, very important, my lord, page 44. Page 44, my lord, 16th April 2024, we wrote 2 different letters to the BJP president. In the first letter, we spoke about withdrawal of resignation from the BJP. My submission would be that resignation could have been withdrawn regardless, expulsion is another issue. So far as resignation is concerned, it having never been accepted by the BJP at any point of time, they were at liberty to withdraw it. They withdrew it on 16th of April 2024 and they have given the reasons also. The reason is, my lord, they have referred to the message of the Chief Minister because on 4th of April, the Chief Minister had given a call. All those who have left BJP or discontent element, they must join the party, strengthen the party, divisive activities should not be carried out. So they write very clearly, we, the undersigned 4th PM of K. Penno district has resigned on 28th of May 24 from the primary membership of BJP in protest. Now we have decided to withdraw our resignation and will remain in the party. We have been informed that young and People's Honorable Chief Minister Shri Pema Khanduji have appealed to PRI leaders to come back to the party they recently held such and such. So withdrawal of resignation from primary membership of BJP in the first letter, and in the second letter they say we have rejoined the BJP, etc. So 2 letters written by them. So letter of resignation withdrawn. Thereafter, my lord, on 23rd April 2024, the state president of the BJP again writes a letter to Deputy Commissioner Member Secretary, Lord Subansiri Jila Parishad, referring to their withdrawal of resignation and rejoining the party. The stand of the BJP on that. I'm going to read it because it is relevant for my case. Page 46, second paragraph, my lord. I read, The State Disciplinary Action Committee has been apprised by the District President BJP, Unit Lower Subansiri K. Penyor, that amidst the dependency of disqualification proceeding against them, the above mentioned expelled members are now reportedly claiming that they had recalled their merger to NCP Ajit Pawar. It appears that they are claiming that they have made an ethical decision to respond to the clarion call of the Honorable Chief Minister to all misguided PRIs to return to the party fold on or before 17th April 24 before 17 hours. That was the deadline given. 17th of April 2024 before 17 hours. We joined on 16th of April. It is to apprise your kind office. It is to apprise your kind office that Bharatiya Janata Party of Arunachal Pradesh is strongly praised for disqualification of the above members. The claims of withdrawal of merger to NCP Ajit Pawar of the expelled members are nothing but calculated afterthought claims made in order to escape from the consequences of expulsion and disqualification. So, my lord, the BJP's stand is nothing doing. They may say that they have rejoined the party. They may say they have withdrawn the resignation. They may say that they are not merging. Don't listen to all this. Expulsion stands and disqualification proceedings should be carried out. This is the, my lord, stand of the BJP. My lord, next page, page 48. On 26th of April 2024, reply to the show cause was given by the four petitioners. I will only refer to the relevant paragraph of this reply. Firstly, my lord, page 49, the last 4 lines. Page 49, the last 4 lines. I read, however, owing to non-clarity on separation of power Jilla Parishad constituency in respect of Lower Subansiri district and K. Pendaur district, as a resultant, we have already withdrawn the merger application dated 28/3/24 submitted to your good office, such and such. Then, my lord, paragraph 5 at page 50. We beg to inform you that NCP Ajit Pawar has not accepted our merger letter dated 28th March 24 addressed to your good office. The merger application was submitted under misconception regarding the notification of newly created district K. Pendaur. Also, the merger was under the impression that creation of new district would naturally entail new PRI connoting 2/3 majority in such predicament. Since our merger has not been accepted by the NCP Ajit Pawar and no formal joining was completed. Also, undersigned has made an ethical decision to uphold the sanctity of the appeal made by young and dynamic Honorable Chief Minister Shri Pema Khanduji on 4th of April 24 to all the misguided PRIs to return to the party on or before 17th April 24 before 17 hours. Accordingly, the undersigned 4 JPMs has already recalled and withdrawn the merger application dated 28th March 24, submitted to your court office, while dated 16/4/24, and also withdrawn the resignation from primary membership of BJP, and same has been sent through mail and registered post to your good office. Also, we have rejoined the BJP on 16/4/24, and same has been acknowledged to the party office in K. Pendaur district, such and such. So, my lord, this is the reply. And they requested for recall of the to cancel the disqualification proceeding, such and such, such and such. Finally, my lord, nothing happened. And the impugned order of disqualification was issued, dated 14th of May 2024. Here, my lord, I will take my lord to the relevant portion. The entire narration, my lord, narration of facts is there, not the finding of the Deputy Commissioner at page 52. Page 53, the same narration of events, not from submissions of the lawyers on page 54. I will skip all this. And page 55, the same thing. I will straight away, my lord, take my lord to discussion of law on the subject, Ravi S. Nayak, etc., etc. I will deal with that. Findings at page 58. I will read the findings of the Deputy Commissioner. Page 58, findings. It is neither denied nor refuted that the 4 Jilla Parishad members voluntarily tried to merge with NCP Ajit Pawar under the misconception that the bifurcation of the district of Lower Subansiri into Lower Subansiri and K. Pendaur district, the Jilla Parishad also stands bifurcated, and that they form more than 2/3 of the elected member of Jilla Parishad for K. Pendaur. it is pertinent to mention here that the Jilla Parishad of undivided Lower Subansiri district has 20 members, out of which 14 members belong to 01 block, Lower Subansiri, and 6 belong to 02 block, now Cape Aneo. The matter regarding bifurcation of Jilla Parishad of undivided Lower Subansiri district was referred to a State Election Commission, who via WT message dated 10th April 24 replied that the Jilla Parishad has been not yet constituted in respect of Cape Aneo district. That subsequent to the merger attempts made by the 4 Jilla Parishad members, while their letter dated 28th March 24, the BJP expelled the said members, while their expulsion order dated 7th April 2024, and that the request of the 4 Jilla Parishad members to rejoin the party by withdrawing the resignation has not been considered by the Disciplinary Action Committee BJP of Arunachal Pradesh. On the question regarding whether the disqualification matter can be instituted and orders be issued, while the model code of conduct such as that, where he said model code of conduct, nothing doing, it can be done. This is the argument I will not make, my lord. Order. In view of all the material facts, as stated above, and the relevant provisions of the Arunachal Pradesh Local Authorities Prohibition of Defection Act 2003, I am of the considered opinion that the action of 4 Jilla Parishad members, namely such and such, attracts disqualification under Section 3 of the Arunachal Pradesh Local Authorities such and such Act. This is what it is all about. So, my lord, now my submissions. Number 1, order of expulsion of the petitioners was a trigger to initiate disqualification proceeding, nothing more, nothing less. Number 2, their act of voluntary resignation from the party holds no water because that resignation was never accepted, never acknowledged, and in any case, my lord, the resignation was withdrawn. And they also wrote a letter rejoining the party. So, my lord, in any case, my lord, the deputy commissioner has not taken into consideration.
No, the second point, please explain. I did
I
not follow
repeat, my
it.
lord. Number 1, it is only the expulsion which is a trigger for initiating disqualification proceeding. Expulsion may be, again, my lord, since the order in the show cause notice initiating, my lord, show cause notice pertaining to initiation of expulsion proceeding. But one would presume from the facts that the trigger was their expression of intent of merger with NCP Ajit Pawar Group. One would presume that. Possibly because of that, the party immediately initiated the next day expulsion proceeding. Possibly. Expulsion came after 7 days. In between, they resigned from the party. Also, my lord, subsequently, they withdrew their resignation. They also rejoined the party, etc., etc. Party never accepted the resignation. Party never accepted the rejoining of the party. All the things considered, party only stuck to the expulsion. So, my lord, what remains on the paper is the expulsion. So far as my conduct is concerned, my conduct has got multiple components. The one component of my conduct is initiation of merger. Another component of my conduct is resigning from the BJP. Yet another component of my action is withdrawal of resignation. Another component is intention to rejoin the party. So, my lord, my conduct constitutes various activities. Selectively, you cannot take one activity, you segregate another activity. Be that as it may, the deputy commissioner in the present case has taken into consideration only the factum of expulsion, nothing more, nothing less. Deputy commissioner does not take into consideration the factum of my resignation, because deputy commissioner himself says resignation, he doesn't discuss that. He simply says totality of facts, I am expelled from the BJP, and this attracts disqualification under Section 3. We cannot read something in the order which is not there. Order is to be read for what it is. Mohinder Singh Gill, you can't improve upon the order. No, I ask myself a question, whether my conduct as a whole would attract the essential ingredients of Section 3 of the Prohibition of Defection Act 2003. Let us read for a moment Section 3. It is two parts. I hope my lord is having, I'll give a book otherwise. My lord, may I
volume?
give? I have
Which
another.
volume? Which volume?
My lord, I am giving either volume 8.
8.
Lordship may see this.
No, I haven't.
Very well.
I'll be preparing it.
Section 3 below reads disqualification on the ground of defection. Section 3, subsection 1, subject to the provision of section 4. Section 4, my lord, has been omitted. It talks of a split. It has been omitted by an amendment. The split is no longer there. The merger remains. Section 5. Section 3, whether my lord has got it.
Yes.
Section
Got
3.
it. Yes.
Subject to the provisions of section 4, 5 and 6. 4 below as I have submitted is omitted now by an amendment. The split is gone. 5 is a protective shield of merger. Belonging to any political party shall be disqualified for being such a member, A, if he has voluntarily given up his membership of such political party, or B, my lord, I would not read because B is not attracted in the present case. It is nobody's case. B. A is the case. Now, my lord, voluntarily giving up the membership of political party has been explained by the Supreme Court in various judgments. I presume my esteemed colleague knows the law. Let us, my lord, understand what the law is all about. My lord, it is in G. Vishwanathan. I'll come to the law now. In G. Vishwanathan, my lord, the Supreme Court clearly and categorically said, leave aside other actions, other anti-party activities. Even if you are expelled from the party, expulsion would ipso facto lead to your disqualification from the party. Expulsion should be considered to be a factor in G. Vishwanathan. But, my lord, in Amar Singh case, it is in 2011. Amar Singh, I will cite all that. In Amar Singh, my lord, Supreme Court doubted the correctness of this proposition advanced in G. Vishwanathan. The Supreme Court said, the moment you say expulsion would lead to disqualification, you give a blanket power to a political party. A power which will be used to subjugate independent mind of the members. So, this proposition does not look very sound. And in Amar Singh case, my lord, in 2011, the Supreme Court referred the matter to a larger bench. Now, my lord, and what the Supreme Court did in 2011, it put a halt on this portion of G. Vishwanathan judgment, that expulsion would lead to disqualification. Now, my lord, 5 years situation remained like this. Amar Singh got the stay. In 2016, the Amar Singh case was heard by a larger bench. Larger bench said, with the flux of time, the issue is no longer a live issue. We would leave the issue open to be decided sometime, and the issue was not decided by a larger bench in Amar Singh in 2016. What happened thereafter? In 2017, issue again came before the Supreme Court. Again, Amar Singh reopened, and Supreme Court said, well, the issue was not decided, issue is a live issue. It is to be decided. And in 2017, which I will refer, the Supreme Court referred to Ravi S. Nair and also G. Vishwanathan and referred to that proposition in 2011 Amar Singh case and said, larger bench is required to be considered, expulsion ipso facto would not lead to disqualification. And continued the halt on the G. Vishwanathan dicta. That is, my lord, 2017, 13 SCC, page 222.
2017.
Yes. 2017, 13 SCC, page 222. I'll just read, my lord, a relevant portion from G. Vishwanathan case, which the Supreme Court quoted.
So before that, one more thing. You see, under the that in the state of Assam, we have that Panchayat Act,
My lord.
there is a provision I forgot, 103 or 107. It says that Representation of People's Act would apply. So therefore,
127.
127, okay. So that applies. Now to import that interpretation of Schedule 10 of the Constitution, whether you can transgress from this 2003 Act and visit a interpretation made under the Representation of People's Act and Schedule 10 of the Constitution.
My lord, I'll answer this. I will answer this first of all. For a moment, I'll just refer to. It is 127, right? Of the Panchayati. I'll just check for a moment.
Assam.
Assam, it is a central act. So Assam Act, my lord, again, Assam Act, it will not be applied in Arunachal Pradesh.
No, I'm saying parameter.
But I'm answering the legal issue, my lord. I'm answering the legal question. I asked myself as to whether the expression voluntarily resigning from a party used in section 3(1)(a) of the Prohibition of Defection Act 2003, how do we interpret it? I would submit, my lord, that so far as the expression is concerned, expression is perimeteria. Perimeteria to the expression used in the 10th schedule to the Constitution is perimeteria. Absolutely. Since it is perimeteria, there is no difficulty, my lord, in importing such an expression and the manner in which it is explained by the Supreme Court. And my lord, there are so many High Court judgments on this very aspect. In fact, my lord, I would say that apply the test laid down by the Supreme Court in the Ravi S. Nayak case on my conduct. My lord, if we apply the test, which has been copiously quoted, my lord, in Amar Singh 2, that is, my lord, 2017-13 SEC, my lord, I am referring to Amar Singh, they have copiously quoted from Ravi S. Nayak. Now, my lord, Ravi S. Nayak clearly says it is an action, the conduct, which would give rise to a situation from where a reasonable person can draw an inference as to whether or not person should be. It can be said that the person has voluntarily resigned from the party. Now, my lord, if we apply that very particular test of section 3(1)(a), quote unquote, voluntarily resigning from a party, my lord, let us accept the 4 or 5 factors available in the present case. What are these factors? Number 1, I resign. Number 2, resignation not accepted. Number 3, I withdrew the resignation. Number 4, I specifically write a letter and say I am rejoining the party. Number 5, I say I am loyal to the Chief Minister, that I heeded a call to the Chief Minister. I simply say, my lord, and here comes the element of arbitrariness. You take one aspect of my conduct, you leave aside other facets of conduct. But, my lord, in this case, even that has not happened. In this case, they have not taken into consideration any facet of my conduct pertaining to resigning and pertaining to withdrawal of resignation. What they have taken into consideration is, quote unquote, expulsion simpliciter. Nothing more, nothing less. So therefore, my lord, I ask myself as to whether expulsion simpliciter would entail disqualification. The order of Deputy Commissioner talks about expulsion of the petitioners and the consequences arising therefrom. It does not in any manner accuse me of voluntarily resigning from a party and takes into consideration the various circumstances surrounding my conduct of resigning from the party. There is no discussion on that. Deputy Commissioner does not apply his mind at all. So therefore, I submit, my lord, the decision of Deputy Commissioner saying or holding that my conduct attracts disqualification with the meaning of section 3(1)(a) would not hold water prima facie. My lord, at this stage, I can only satisfy my lord prima facie. It needs elaborate hearing and various propositions have to be visited. Whether my lord I have made out the case of prima facie satisfaction to your lordship. Because, Lord, they are elected members. They have 1 year to go. Fact of the matter is, my lord, if a new Jila Parishad is constituted in K Penyor, they will be in the majority. And my lord, the process of constituting new Jila Parishad has already been initiated. The last document, my lord will see. The last document. Page 61. Constitution of Jila Parishad. Automatically the 6 come into new 21st May 2024, page 61 of the paper book. Constitution of new Jila Parishad. Secretary, State Election Commission, Itanagar, writing to Deputy Commissioner K. Penyor. With reference to government notification number such and such, he refers to the 23rd February 2024 notification regarding creation of a new district out of Lower Subansiri. In this regard, you are requested to furnish the serial number and names of Jila Parishad constituencies falling within the jurisdiction of K. Penyor district to this commission with intimation to DC Lower Subansiri immediately. Process has been already initiated to constitute a new Jila Parishad. Deputy Commissioner of Lower Subansiri is on record saying that out of the 20, the 6, including these 4, will be part of a new district. That's a fact. On top of it, my lord, what has been taken into consideration while passing the impugned order of disqualification? Expulsion. So, my lord, I urge my lord, there is a prima facie case for my lord's intervention. Let there be a short date. We'll argue the case on merits in toto. They are elected members, my lord. The balance of convenience is on their side. Let them continue. Apparently, party wants to punish them. I understand without anger in the party. But should Dennis the man's position be applied in the present case? That's my question, my lord. I ask myself. So, my lord, that's my humble submission. Lordship will consider it holistically, in a comprehensive fashion, taking into consideration in totality my conduct as a whole, not the parts of it, but whole. In any case, my lord, this conduct has not been treated by Deputy Commissioner.
Yes.
I should submit before Lordship that well tried by my learned friend. And it's not a case of resignation. It's not a case of whether resignation was accepted or not. It is neither a case of expulsion nor a case of, my lord, merger. It is the question is section 3, my lord. My learned friend has not very emphasized on the requirement when section 6 will be invoked. Section 6 of the Act was 2003 was invoked because there is voluntary giving up of membership of a political party on whose ticket you have been elected.
Section 3.
Section 3A. That is the question, madam. Each and every conduct, any of the conduct taken independent of the other is not a question. Question is by overall what was your conduct? This is the Ravi S. Nayak. My learned friend has not read that judgment also. I'll read that judgment. Well, Supreme Court says it is your conduct. You resign from one party. Why do you resign? You are in a haste. Had they waited for another 1 month, my lord, they would have succeeded in merging with NCP. Because they have made their intentions very clear. We have got, my lord, newspapers to show that what anti-party activities they have indulged in subsequently. My lord, right from the beginning, they have submitted, my lord, my learned friend has not very clearly stated. There was a joint, two subsequently created district.
There are two perspectives. Number one, the perspective and the spectacle with which the party is looking at it. There is another perspective and spectacle by which the Deputy Commissioner had passed the order. So I'm not on what the party is doing. Okay. Party's conduct is absolutely irrelevant here. What is relevant is what is their conduct. Supreme Court has said their conduct. Resignation is not nothing. My learned friend is again and again insisting that I submitted a resignation and there was no acceptance. You never submitted a resignation. It is your documents which are saying that by an application for merger, there is no intention to merger. It is a merger application.
Subsequently, by application to withdraw that application, you are saying that I am withdrawing my application for resignation from primary membership of the party. These are your conduct. You have come out from the party. You have also said that since a new district is created from the bifurcated Jila Parishad, 4 members will come into the new district. I'm sorry, 6. Out of that, 2/3 becomes 4. So 4 of you have joined together to ensure that you do not fall under the mischief of the defection law, and you become a new party, you merge with NCP, and then you get protected also, and you become a part of NCP. That was your conduct. With this conduct, can any person say that I have intention even still to remain with the party by which I was elected? You have, by your conduct, not one, several things. I'll show my one by one. You have made it very clear that you have voluntarily given up your membership or not. That is the question, my lord. Now, Lord, will you kindly say, I'll not take much time and I'll just show 2-3 things, my lord. Yes. It's a very crystal clear case, my lord. I have given the list of dates, my lord. 23rd of February 2024, there was a notification that a new district called KE Penure district will be created from 1st of March 2024. Immediately thereafter, my lord, 28th of March, they file an application saying that they want to merge. Now, Lordship, may I kindly turn to page 31. I just quickly take your Lordship to these documents, my lord. There's no question of any intention to merge. It is a document to merge, as your Lordship has rightly pointed out, my lord. Page 31A. Issue is not whether merger has in fact taken place or not. Issue is by your application to merge with another party, whether you have voluntarily given up your membership of the party on whose ticket you were elected. My lord, kindly take page 31A. It is to respectfully inform and bring to your notice that we, the undersigned, 5 ZPMs, including the present ZPC, out of total 6 ZPMs of KE Penure district, do hereby merge to NCP with more than 2/3 majority. Two things they are making very clear here, that we are merging with NCP, and secondly, with a 2/3 majority, so that we don't face the rigor of that anti-defection law that if it is less than 2/3, you are disqualified. So they to ensure that also they are very clear that they are going with the protection given by the Act, that they will go and merge with 2/3 majority. Then, my lord, next document straightway is the page 33. This is a letter from the BJP. As your lordship said, what was the conduct of the BJP? To some extent, that may be relevant. BJP has said that, see, this is with reference, page 33 I'm reading. This is with reference, lordship has got my page 33. This is with reference to written complaint and representation received by the party office about your alleged misconduct, non-adherence and non-compliance to the directions, notifications or circular issued in the interest of the party. Furthermore, allegations that you are indulging into anti-party activities for your self-vested interest. Our party believes in your observing high ethical values in all aspects and expects the same from all its party members, leading to a healthy organizational environment. Below, undersigned has taken a serious note of the same and hereby condemns the same and issues show cause notice to allow you to put forth your explanation. They do not submit any explanation because they do not want to come back. They are not concerned with the discipline of the party any longer because they have already made it very clear that we are going to NCP. So page 34 is their reply. I'm sorry, page 34 is the expulsion order. Separate expulsion orders were issued. Now, next page, page 38. Page 38. Well, page 38 is the letter. And the second page of page 36 actually is not the second page of this petition, my lord. It is page 47. And my learned friend has continuously read it, but that is not the correct position, my lord. Page 38, the letter written by the party president comes State Disciplinary Action Committee to the member secretary who is to take action of disqualification, my lord. Second page is at page 47, my lord. Second page of this letter to initiate a proceeding for disqualifying them is at page 47. Lords may take note, man.
Thirty-nine is not the continuation page.
No, man. Page 30, second page of page 38 letter is page 47, man.
Okay. Yes.
So this is the letter. We are saying that because of these activities, we have written to the member secretary Jila Parishad to disqualify them. Second page, my lord, at page 47, Lord may kindly see. We have also enclosed the action order, resignation letter, and newspaper clips for your reference. They have given a reply to this line. Page 48 is the reply. And at the outset, I'll submit to your lordship.
You're reading which page?
My lord,
You're reading which page?
page 48, my lord. 48 is their reply. To the show cause notice.
What is it? 40?
For 48, my lord, 48.
48.
My lord. This is the reply of the show cause notice issued by the deputy commissioner to disqualify them, my lord.
Oh, just a moment. I just informed members of the bar. 4:15 I have to rise today. There's a meeting.
I'll conclude. 4:15. My lord, in this reply to the show cause notice at page 48, my lord, they have only tried to justify why they were in a hurry. And they were under wrong impression that new district has already been created. They are nowhere saying that our anti-party activities were incorrect, nor are they saying that our activities do not constitute an act of voluntarily giving up the membership of the party. That they are never saying. They are only saying that why we were in a hurry, what was our mistake, because we immediately filed the application, because we were under the impression that new district has already been created. And if the new district is created, 5 out of 6 of the newly created to be constituted, my lord. That's section 8 will be 2/3 majority. So we would have saved ourselves from defection, disqualification. That is what they are saying, nothing else. And my lord,
I'll just take a break and come back.
my lord. Opinion district, we the elected 4 BJP ZPMs has decided to merge with Nationalist Congress Party Ajit Pawar in protest of present leadership of the constituency, and accordingly we the undersigned submitted merger application to our by dated so and so with outside support from one independent ZPM of Pitapul in a bona fide belief that power and function of Jila Parishad constituency has been separated for KE, Penyor and Lower Samudra district. This paragraph itself shows they are admitting the fact that they wanted to merge with that party, and how and in what manner and how by saving their disqualification. Because if it is 2/3, they will save themselves. So this goes to show their intention was absolutely clear. Even by the reply also, they are not saying that they wanted to continue with membership of the party on whose ticket they were very late. And my one page, just one document page. I'll not take much time of yours. Page
This is a daily story between husband and a wife.
Yes, yes, absolutely correct. Perfect example.
You know, Arunachal throws up unique challenges at times. It's a unique case. I have looked into various judgments. Facts are rather strange and peculiar here.
My lord, page 44, I'm just referring to for a moment, my lord. Here they are saying we the page 44. This is their withdrawal application. Page 44. Their withdrawal application to the party president. We the undersigned hold the ZPM of KE Penal District. Page 44. Madam. My lord, this
Because in extension to what I have said, every time I walk out,
Right.
and then when I come in, I'm not let in without a gift. So if I carry a gift, then it's okay. Perhaps these people did not make an entrance with a gift.
yes, we should understand that, my lord.
Outside you reconsider it. He's got the hint. Outside you got to decide and give him a hint.
Yes. Well, at page 44, I am just pointing out one thing. We, the undersigned for ZPM of KE Penal District, has resigned on 23/20/24 from the primary membership of BJPs in protest. From here, I want to show two things. There is no separate resignation letter as such. It is the 23/2024 letter of merger at page 31. Same letter, man. There is no separate resignation letter. And secondly, they are saying that their intention was to resign from their primary membership of the party in protest. Now, my lord, in view of this conduct, number one, you wanted to resign from the primary membership of the party. Number two, you have submitted application for a merger with NCP. And you have undertaken anti-party activities. All these things, my lord, were taken into consideration in the facts of the case discussed by the Deputy Commissioner in detail. And in the things at page 58, Lordship will find, when the facts are admitted, there is no question of recording any separate finding on that. Page 58, Lordship kindly see, it is neither denied nor refuted. Page 58, my lord. It is neither denied nor refuted that the four LP members voluntarily tried to merge with NCP. Page 58, my lord. If you voluntarily try to merge with a party, it is another thing that merger has not taken place. We are not concerned with whether merger has taken place in fact or not. What we are concerned is, what was your conduct in submitting an application for merging with another party? So you have not neither refuted nor denied that you have voluntarily tried to merge with the NCP. My lord, my case is far better than the cases reported in the Supreme Court. Well, I'll just show, my lord. Under the misconception that the bifurcation of the district of Lower Subansiri into Lower Subansiri and KE Penal district, the Jila Parishad also stands bifurcated. That was only their mistake, that they were under the impression that new district has already been created. But the problem is, my lord, under the Panchayat Act, section 85, subsection 1 says, the government may, district has been created. Section 85(1). Yes. From the State Election Commission may, by notification, constitute a Jila Parishad for each district with effect from such date as may be specified therein. And the last page of the present petition, my lord, has shown that they are yet to notify. So the new district has not been created till date. District is created.
Put it back.
New district is created, but Jila Parishad is not created. So in that matter, your application to merger was premature. 61. Section 85. My lord, page 61, it has been already referred, my lord. There it says, my lord, the State Election Commission has issued a letter saying that State Election Commission intends to notify constitution of Jilla Parishad in your district. So that notification has not come as yet. My lord, my lord, first judgment I am relying on is 1994 supplementary 2 SCC page 641. I'm giving a copy.
1990?
1994 supplementary 2 SCC 641 para 11. Ravi S. Nayak.
641.
641.
RS Naik.
Yes, Ravi S. Nayak. Para 11. I'm I can read state, this refers to two persons from MGP, my lord. In the middle, Lordship will find after
Which page?
page 649. Last one, 649.
Yes.
Well, I'm not reading the entire paragraph, my lord. If from the middle, my lord, you also will find ground of paragraph 21A only is mentioned in the middle of the paragraph, my lord.
Is President C.
Yes, President C. Just the sentence starting from the full stop, my lord. The said paragraph provides for disqualification of a member of a house belonging to a political party if he has voluntarily given up his membership of such political party. The words voluntarily given up his membership are not synonymous with resignation and have a wider connotation. A person may voluntarily give up his membership of a political party even though he has not tendered his resignation from the membership of that party. Even in the absence of a formal resignation from membership, an inference can be drawn from the conduct of a member that he has voluntarily given up his membership of the political party to which he belongs. In my case, the conduct of these four petitioners are more than clear that they do not want to continue with the membership of this party. They have resigned, they have filed application for merger, everything, they have made their intentions very clear. Second time released that Vishwanathan judgment, my learned friend has referred, 1996, 2 SCC 353.
All these paragraphs are quoted in that Amar Singh, which I had cited. Exact paragraphs are quoted.
Here also, my lord, paragraph 11. That your lordship will find at page.
But Vishwanathan has been put on hold by Amar Singh too.
Page 361. Well, to 361. It appears that since the explanation to para 2(1) of the 10th schedule, my lord, I'll not read the entire paragraph from the middle again. He will continue to belong, Lordship has got, my lord. He will continue, President D.
Just a
D.
moment, just a moment.
Right.
This 2017-13 SEC, you say that this G. Vishwanath has been kept at hold.
Yes.
Where is that?
It was put on hold, my lord, by Amar Singh 1 and Amar Singh 2, Amar Singh 1, and then again the hold was maintained.
Where is that observation?
My lord, just a minute. Para 8 and 9, as we find, my lord, page 227. Sorry, lordship may take my book. Amar Singh 2, 2017-13 SEC. Lordship may take from para 8, lordship may read.
2011?
Sorry, 2000.
As we find. No, as we find.
My lord,
Because I look at the book.
lordship has opened it. I'm sorry, I ought to have wrote the extra copy. But my lord, that is there. Very well. Para 8, I read, my lord. As we find in the case at hand, the term of the petitioner shall be up to 4/7/22. Thus, the reference that was made in Amar Singh, that is, they have referred to that 2016 larger man. The present petitioner remains to be dealt with, as the same has not been answered with the flux of time. As the question remains alive today, we think it appropriate that the matter should be placed before the larger bench for consideration of the questions which we have reproduced from the decision rendered in Amar Singh. Then, my lord, comes such and such learned senior counsel appearing for the petitioner prayed for interim relief in terms of para 80 of the decision rendered in Amar Singh. My lord, that is Amar Singh 2011 1 SEC 210.
This shall not be applied in two petitioners.
Pending the reference, the quote is, pending the reference, the decision in G. Vishwanathan case shall not be applied.
In these two
Yes, two petitioners. That is case to case basis. My lord, it can't be blanket.
No, so in
Case to
respect of
case.
two petitioners only.
Yes, that is true. Case to case, case to case.
So it will apply.
And not automatically, we not reach the approach.
No, I'm trying to just understand, because in the back of my mind,
Yeah.
I'm also, the back of the mind is working on this decision of the Supreme Court in Pranay. In Pranay,
I'm sorry, my lord.
Pranay.
Pranay is not Ray, Pranay City.
City,
That National Insurance Company, Pranay City versus National Insurance Company. There, I'll forget the paragraph, it's 36 or 38, where the Constitution bench has come down heavily against in connection with the principle of stare decisis. And the language is best read than said.
My lord is referring to, since it is 141 power of the state assesses, since
No,
it is in respect of the two alone.
No. This is another thing. How the sorry, because the coordinate bench of two judges staying the operation of a coordinate bench judgment is something which is
Whether High Court can do it in exercise of 226, whether High Court can do it. This is the question my lord is raising.
no,
The power which Supreme Court has exercised.
no, not even that. What I'm saying is that whether this observation would be a binding precedent. For that reason, I am thinking about Pranay City. Well, they say that the coordinate bench must follow the earlier decision. So it can at best give a reference for the reasons recorded.
Cannot differ.
But to stay the operation of a judgment of the coordinate bench, this is a power to be exercised. Their lordships have done it.
They have not done it once, but they have done it twice. Here they should notice, and thereafter I'll get that order. Thereafter, not again the same thing. They gave the benefit to the petitioner in this case also. So selectively they are doing it.
Anyway,
The question is not whether my lord will apply the same principle while exercising 226 power is an issue for my lord's constitution. I will look into my lord precedents and case laws on that aspect.
My lord, may I read this remaining part of the paragraph? It's para 11 of Vishwanathan. Plus item D. Just 2-3 lines, man.
So there is only one judgment of Supreme Court where the unique situation occurred. Just can't remember the name right now. It's in a tax matter where larger bench decision of 9 judges was interpreted by a smaller bench, and they said that the larger bench committed a typing error in the order. This does not match in the facts of the case, and therefore we explain the judgment of a larger bench. And that interpretation was later on approved by another constitutional bench, because there was a typing error out of for which hundreds of SSCs got relief, and therefore the lesser strength bench interpreted a judgment of this larger bench and said it was a typing error which is correct. This is the only exception I
My
found.
lord, even without some typing error, sometimes the almost Supreme Court has said, Nagaraja's case, my lord, has decided on a point of law, you ought to be aware of that. Subsequently, there is a judgment of Suryavanshi, where this says that Nagaraja dicta is applicable where reservation is to be made beyond 50%. This is something what was not said in Nagaraja. In a subsequent decision, Supreme Court clarified that this was, although this was said, but it was not there in the Nagaraja.
They attributed something which was not there.
Yes. So, my lord, this
Parallel.
D, my lord, at page 361. The act of voluntarily giving up, lordship has got, my lord. The act of voluntarily giving up the membership of the political party may be either express or implied. So there need not be any express act of voluntarily giving up membership. When a person who has been thrown out or expelled from the party which set him up as a candidate and got elected joins another new party, it will certainly amount to his voluntarily giving up the membership of the political party which had set him up as a candidate for election as such member. It is absolutely clear, man. You have shown your intention to join NCP. Lastly, I am relying on 2 paragraphs of this 2007-4 SCC, page 270. The Constitution Bench, Rajendra Singh Rana, Constitution Bench Judgment, 2007-4 SCC, page 270. Referring to para 48 and 49, at 303, para 48 and 49. Just a couple of pieces. 10 to 1.
Yes.
My lord, lordship may kindly straightway go to page 303.
Yes.
303, para 40, if your lordship has got, my lord.
Yes.
Another conduct was considered. The act of giving a letter requesting the governor to call upon the leader of the other side to form a government itself would amount to an act voluntarily giving up the membership of a party on whose ticket the said members had got elected. Be it noted that on so-and-so, the leader of their party had recommended to the governor a resolution of the assembly. The first 8 were accompanied by so-and-so, the General Secretary of the Samajwadi Party. In Ravi S. Naikar, this was quoted by this paragraph which I referred, para 11, then para 49. Clearly, from the conduct of meeting the governor accompanied by the General Secretary of Samajwadi Party, the party in opposition, and the submission of letters requesting the governor to invite the leader of that opposition party to form a government as against the advice of the chief minister belonging to their original party to dissolve the assembly, an irresistible inference arises that the 13 members have clearly given up their membership of the BSP. No further evidence or inquiry is needed to find that their action comes within the para 2(1) of the 10th schedule. Language is same in the 10th schedule. So this is, well, my submission. It is the conduct. You have till the day of filing your reply to the show cause notice, you are affirming, you are confirming that yes, you wrote a letter, you wanted to join NCP, you wanted to defect with 2/3 majority so that we do not get disqualified. And it is only because the new district was not created by issuing a proper notification that our application could not be considered. This is your stand. What else is required, my lord, to show that he has voluntarily given up his membership? That being the position, my lord, the deputy commissioner has correctly said that if you have not refuted this conduct, section 3 is attracted, and thereby I invoke section 6 and disqualify. That being the position, my submission before lordship is it's not a fit case for interpretation. In fact, matter can be disposed of with these observations by your lordship and the judgment which I have shown. Anyway, if your lordship desires to issue notice, no difficulty, my lord, but no interim order is called for in such a case, man. Absolutely clear.
Only 2 minutes I will take. My first submission is, my lord, that the order of deputy commissioner is apparent, namely that he has considered only 3 factors. Number 1, expulsion. Number 2, attempt to merger. Withdrawal of merger and resignation, and not acceptance of the same by the BJP. Again, I repeat, my lord, deputy commissioner in his finding portion has considered 3 factors. Number 1, attempt to merger. Number 2, expulsion. Number 3, withdrawal of resignation, but non-acceptance of the by BJP. On considering the 3 factors, deputy commissioner has arrived at the conclusion that yes, section 3(1)(a) is attracted. My submission, my lord, is the conduct of voluntarily resigning from a party is a sum total of various actions. Various actions and activities constitute a particular conduct. In the present case, my lord, unlike other cases before the Supreme Court, these sum total of activities, these activities, my lord, have a negative component and also have a positive component. A negative component is being neutralized by a subsequent positive component. That is, so therefore, my lord, one cannot come to a definite conclusion that there is an act of voluntary resigning from a party, because one act was neutralized by another action. That's my submission. So therefore, 3(1)(a) is not attracted. And my lord, the second leg of my argument is, namely, as to whether expulsion ipso facto would lead to disqualification. The dicta of Vishwanath and Supreme Court selectively putting a halt to it. My lord, lordship will kindly give me 24 to 48 hours. I will just see how the other high courts have looked into it, and as to whether Supreme Court itself has applied this at random. Because, my lord, so far as the first aspect is concerned, expulsion automatically leading to disqualification. This is an issue, my lord, deputy commissioner has not considered. But if that is the legal position, namely the Supreme Court can do it, a coordinate bench of the Supreme Court can put a halt to a particular observation of Vishwanath. But whether the Honorable High Court will do it in exercise of power under Article 226 is an issue, my lord, I will have to look into. If this goes against me, nothing survives. Obviously, that is true. Lordship will give me 24 to 48 hours. If I find nothing, there is nothing. Lordship would accept it. But I would submit, my lord, the order of the deputy commissioner, so far as attraction of section 3(1)(a) is concerned, needs to be revisited. Lordship may consider it, my lord. That's my humble submission.
You have a good job. Somebody's chair, somebody's room.
Now, obviously shifted to my lord to come to a conclusion. But my lord, all said and done, this is an interesting case. And one way or the other, my lord, at least, there would be some clarity on certain facets. Because there is lots of confusion as to whether expulsion ipso facto will lead to disqualification.
Supreme Court is very clear, my lord. There is no,
One may say
absolutely
that.
no confusion on the question of facts.
The only question would be,
My lord.
who would be next man to first catch a flight?
Yeah. Your lordship is very practical. Deep lord.
In flight bookings, you can have caveat, no.
I beg your pardon, my lord?
In flight bookings, you can have caveat, no.
Caveat in what?
Supposing you catch a flight or Mr. Mazumdar catches a flight, will you get any information that?
Individual relationships, my lord, caveats are always there. Multiple caveats.
Okay.
My lord, just now, my lord, in fact, a little ago, my lord, there was a caveat in between us.
May I please, your lordship?
Just a moment.
My lord, in this matter, my lord, your honorable court was pleased to direct for the payment of the compensation as per the Lara Act. The order, judgment and order was passed on 8/12/2022. My lord, may I just take to the page 30 is the order, and an operative person is page 36. May I read that one?
Where is this order dated?
Order dated 8/2/2022.
Which page?
It's in page, start from 30.
30.
30, my lord. And operative person is in page 36, para 7, may I read it?
But this writ would not be maintainable. You see, we can't issue a writ for enforcement of another order in a writ petition. You did not file a contempt. That is lost. We can't enforce our own orders by a writ.
We have filed, my lord, on the basis of this order, my lord, the government has prepared the bill, and now it is pending before the authority. That's, but then we are filing writ because the non-payment of the compensation, my lord. They have prepared, my lord.
No. You see, you'll have to show me authority on the point that by issuing another writ, we can enforce other writ. That's not just not permissible. Multiple writs for the same writ cannot be granted. It's well settled.
Because, my lord, what happened was that we could not file the contempt petition. Because of that, we have to hesitate again in this writ petition, my lord.
No, but we can't do it. I have myself authored many orders. Where you said that the writ petition would not be maintainable for enforcing earlier order of the writ. We are not executing agency. We mainly have a power of contempt.
In fact, we have filed representation to the concerned authorities that we should be paid with the bill which has been assessed as per the direction of the Honorable Court dated 8/2/2022, my lord. Our representation, my lord, is in page 71, my lord. Page 71, my lord. What we have agitated is that as per the Honorable Court direction dated 8/2022 to 2023, the department has prepared the bill as per the Lara Act 2013, and the same is submitted to the authority, especially the secretary. And what we have praised that the landowner, they have praised that the money should be paid as early as possible, my lord. That is the representation we have filed on 2nd May of 2024. Reminders, my lord.
No. You see, what happens is that once a writ petition has been allowed,
yes,
by directing that you should be compensated, correct? The present writ, the cause of action will be same.
Yes.
You see, there cannot be a cause of action for enforcement of the earlier writ. That is well settled.
But then after that, my lord, they have fresh reassessed the compensation, my lord. And then follow up, we have further representation, my lord.
No, we don't find it to be maintainable.
2nd May 2024.
We have to make some more convincing argument. Like, we don't find the repetition to be maintainable. Repetitive reads cannot be issued.
Because earlier writ petition, my lord, they have acted upon that, my lord, and then only they prepare the fresh bill, my lord. But that's, my lord, that bill is, my lord, in page, my lord, it starts from page 37, my lord. 37, my lord.
Well, you have to wait till they do it by themselves. By court will not issue a writ to. There can be a contempt, but there cannot be a writ petition to enforce the order of a court.
Page 30 is, my lord, page 37 is the forwarding of additional compensation statement, my lord. As per the direction of the Honorable Court passed in such and such, my lord, filed by the petitioners, my lord. With reference to the subject cited above, I am directed to forward here with the additional compensation statement as per Lara Act. 12% interest for 4 years of land value in respect of petitioners as per the direction of the Honorable High Court. Itanagar bench answer dated passed in the such and such writ petition filed by the Gumjum, Angu and others versus such and such, my lord. And in this regard, amount, my lord, is mentioned, my lord. Only for onward payment to the petitioners, my lord. This was the forwarding letter up to the High Court direction they have acted upon. And then now the bill is pending before the authority, and we have filed a representation saying that the compensation which is reassessed after the High Court direction may be paid to the petitioner. That is how we have agitated again before the authority, my lord. Because earlier, my lord, earlier writ petition on the upon that earlier writ petition they had acted upon, my lord.
Okay, let me examine pass orders because I have not collect. Let me examine.
At this stage, my lord, notice my issue, my lord. At this stage, my lord, notice my issue.
No. I'll examine whether this, I have to retrieve my orders.
Otherwise, my lord, the dismissal will cause prejudice to the petitions. Dismissal will cause prejudice to the petition.
Definitely, because you see, we can't, we said let me check it out, because just right now I'm not equipped. There cannot be a writ for enforcement of another order of a writ. It can be a contempt maintainable, but there can't be a writ. That's the issue. Let's see, just let me examine.
Then, my lord, can be taken tomorrow, my lord.
Let me think over it.
Obliged.
May Lordship. Lordship, here is, Lordship, here challenging the order, mail order, Lordship, passed by the additional Deputy Commissioner Yejali, Lordships. Lordship, here, MP order is at page 19, Lordship, and except to Lordship. Lordship, here, Lordship, this order is passed, Lordship, without jurisdiction, Lordships. After the separations of judiciary from executive, Lordships.
Where is the order against which you have come
Page
here?
19, Lordship,
19.
and except to Lordship. May I read, Lordship? Lordship, clear, it's more visible from government annexure, Lordship. May I read, Lordship? Lordship, page 8 of annexure is clear, Lordship.
This is under AFR.
Lordship.
But AFR says any civil suit.
Yes, civil.
Divorce is a civil suit.
Yes, Lordship.
Then
Civil suit, Lordship. Here, civil suit, Lordship. Mail order is issued by the additional deputy commissioners. Lordship, he just in FR, Lordship, as per the provisions of FR, Lordship, he just to refer the case to the village authority, Lordship. Here is the case, Lordship. He fixed the matter, Lordship.
correct, that's what the orders are. There's not one order. I've seen hundreds of orders like that.
He is not
The
Lordship.
deputy commissioner or the executive ESC,
Yes, Lordship.
they write in the orders that the so and so is constituted and they will hold the mail on so and so or a village kabang on so and so.
Lordship, have no power to fix the Kaba, Lordship. That is in the Lordship. If Lordship is Perus, Lordship, this mail order, Lordship, order pass, Lordship. This is to be on.
This why not? People are before him. He's saying that you just see AFR.
Lordship, FR, Lordship, amendment FR is here, Lordship. Lordship, section
20 resolution AFR.
4, Lordship.
Hmm?
4, Lordship.
This is volume number.
Volume 1, Lordship.
Volume 1.
Volume 1 and Lordship, edition 2023, Lordship. Lordship, page edition, Lordship, 2023, Lordship. Page number 51, Lordship. Section 4, Lordship. May I read, Lordship?
Page.
Page 51, Lordship.
Oh, this book. Okay.
Yes, Lordship. Page 51, Lordship.
Ah, yes.
Lordship, edition, Lordship, 2023 edition, Lordship. 2023 edition, Lordship.
No, this is not 23.
Here is the edition, Lordship. Kindly peruse, Lordship, 4, Lordship. Mary, Lordship.
Yes.
Lordship, here, Lordship. amendment to section 4, Lordship. This is amendment, Lordship. May I read, Lordship? Subject to provisions of this regulation, assistant commissioner or deputy commissioners, as case may be, shall refer back the case.
Please see that if the deputy commissioner has fixed a date
Yes, Lordship.
or his representative has fixed a date for the mail,
Yes, Lord.
how are you prejudiced?
Lordship, I am prejudiced, Lordship. This is fixed on general ground, Lordship. This is an offend area, Lordship. This is the ground, Lordship. Matter is fixed before a general ground. Lordship, this cannot be. This cannot be. This is a violation of FR, Lordship. Section, Lordship. Lordship, may I show, Lordship? There is a section, Lordship. This to be delivered before the specific Kavangar, Lordship. Designated Kavangar, Lordship. May I read first?
Which section?
Lordship. Section, Lordship, 44, Lordship.
Yes.
May I read, Lordship? All suit tried by the blade authority shall be decided in offender in the presence of parties and at least 3 independent witness, Lordship. This Lordship, not offender, Lordship. There is Kavangar, Lordship. That is to be in the Kavangar, Lordship, not on the general ground, Lordship. Or Lordship, in this connection, Lordship, there is a this case, Lordship, one case, Lordship, of this coordinating bench, Lordship, is deciding on this aspect, Lordship. May I, Lordship? Yes, Lordship. 1, 2, 3, 4, Lordship. Up page, Lordship. May I read, Lordship?
Yes.
Paragraph 4, Lordship. On perusal of judgments referred by learned counsel, it is clear that neither the deputy commissioner nor his subordinate enjoy the power to take up civil dispute nature in any longer. Therefore, the impugn order dated so and so passed by respondent number 1, additional deputy commissioners are hereby quashed and set aside. Therefore, party are liberty to approach appropriate forum for resolving their dispute if so advised, Lordship. Lordship, here is a fact, is same, Lordship. Here the complaint is made by the private respondent, Lordship, for conducting of Kava before the additional deputy commissioner, Lordships. And to that effect, Lordship, this impugn order is passed, Lordship. And Lordship, moreover, Lordship, in their affidavit, Lordship, the respondent number 1, Lordship, respondent number 2 invoke the provisions of section 2 of
May I please, Your Lordship? Lordship, I'm appearing for respondent number 2. Your Lordship, the ADC and in the ADC has issued the impugned order here in this case, Your Lordship. And via this impugned order, ADC was only facilitating the mail
But it's
proceeding.
showing a judgment where this court, even on the issuance of the order of mail, has set aside the order.
But Your Lordship, according to
I don't know, you check up this order, you give a copy to her.
I have lordship.
Give it to her. You see page 1, para 1. A notice was issued directing the mail to be held on so and so dates. Para 1. And the last para of the order, has been passed.
What happened is, Your Lordship, in this case, Your Lordship, the mail procedure was not completed, Your Lordship.
Here also
It
is
was
not complete.
still under the process, Your
Here
Lordship.
also it is not complete. You have read the order. The state has not filed any appeal against this order.
This is order of 2018, Your Lordship. But it has been amended in Arunachal Pradesh Civil Code Amendment Act 2022, Your Lordship. According to our annexure in our counter affidavit, Your Lordship, page number 13, annexure 5. May I read, Your Lordship? Section 2, amendment of section 10, Your Lordship. In Arunachal Pradesh Civil Codes Act 2021, heading after called the Principal Act, in section 10, after proviso 3 to subsection 3, the following subsection shall be inserted, Your Lordship. 4. Notwithstanding anything contained in this act or any other law for the time being enforced, whenever a civil suit is instituted for trial by the village authorities, the concerned local administrative officer of the area shall continue to facilitate and refer back the case to the concerned village authorities for trial under the provisions of Assam Frontier Administration Regulation 1945. So, the ADC has acted on this provision. He have only referred back the to the local authorities. The petitioner counsel, he is referring case law of 2017, Your Lordship. It hasn't set aside.
Lordship, still this is enforceable lordship. As because lordship.
No, the
now
new law has
this
come up, Your
no
Lordship.
this even
It has
Please don't argue. Just let me examine it. Okay, yes, then
Yes, Your Lordship.
anything else?
Yes, sir, I'm submitting that ADC was only exercising his power of facilitating the mail proceeding, Your Lordship. Because the respondent number, private respondent, he has approached the office of the ADC. That is why, Your Lordship, this order was, consequently, this order was passed, Your Lordship, after his application, Your Lordship.
Yes,
May I, Lordship, this actions, impugn actions, Lordship, is the encroachments of executive to the judiciary, Lordships. Here, Lordship, executive by executive orders, executive directing the court, Lordships. After amendment of this civil code act, Lordship, it's assumed to be it's deemed to be a court, Lordship. Village authority is deemed to be a court, Lordship. After the amendment of the civil implementation of the civil code act, Lordship, 2021 act, Lordships. So, Lordship have no power, Lordship, and jurisdiction to issue this order, Lordships. If Lordship refer back, it's no problem, Lordship. Here is the case, Lordship. They overpower the judiciary, Lordship. Pass the order to conduct, Lordship. Kaba, Lordship. Mail and fix the case, Lordship. This is illegal, Lordships. I have no jurisdiction, Lordship. Therefore, Lordship, these impugn orders may be interfere, Lordship. Moreover, Lordship, these provisions which my friend read, Lordship.
Lordship of the Civil Courts Act.
Lordship, my friend read the provisions of this 2022, Lordship. This is amended again, Lordship. What earlier, Lordship, seen, Lordship, is the amendment of 2023, Lordship. I have the amendment copy, Lordship.
So why you are giving piecemeal?
No,
If you
Lordship.
have things, both of you can give it
Lordship.
together. You are giving
Lordship.
piecemeal. Once I apply my mind in
No,
one
Lordship.
aspect, then you say that you have another amendment. You could have given a bunch.
No, Lordship, I already provide to you, Lordship, this act. In this act, Lordship, it's corporate, Lordship.
Book.
Lordship.
So therefore, you
This
should
is
be-
the amendment, Lordship. Again, Lordship. Lordship, first page, Lordship, bottom, Lordship, bottom line, Lordship.
Civil Courts Act.
Lordship, Civil Code Act is annexing enclosed in my writ petition, Lordship. First, 2021, Lordship.
Okay. Yes.
Lordship, this civil code, as per this civil code, Lordship, annexure 4, Lordship, and cause annexure 4, page number 23, Lordship. Civil code meaning given, Lordship. This civil court means court of district judge, court of or an additional district judge of civil, a civil court judge senior divisions, a civil court of civil judge junior divisions, or a customary court including blade authority by whatsoever name called under Assam Provincial regulations. And Lordship, after this, Lordship, clause D, Lordship, explain the customary law, Lordship, again. Customary court, Lordship, sorry, Lordship, customary court, Lordship. Customary court means traditional council or blade authorities indigenous to the state by whatsoever name called or include or court of blade authority under section 5 of Assam Provincial Regulation Act, Lordship. Lordship, this court cannot be inter order laws. Maybe please to quash this impugned action lawsuit passed by the Education Commissioners Yazali lawsuit. On this ground lawsuit.
Well, Mr. G. Bamper comes for the petitioner, as well as Ms. T.
Please
Wangmo,
sing it, Your Lordship.
General Counsel for the General Government Associate. Argument is concluded, judgment is reserved.
Congratulations.
May I please your lordship? Lordship, I am for the petitioner here.
Yes.
Lordship, this matter is in regards to lordship non-payment of bills by the forest department, lordship. My
Yes.
JCB was hired, lordship, and then we incurred certain bills, lordship, that they are not paying, lordship. Now, in their affidavit, lordship, they have admitted that 8 lakhs is
Hired, Your Lordship.
due.
Hired
lordship.
for construction of Your Lordship. But out of that 13 kilometers 6.45 100 per hour, Your Lordship. But his contention is that, Your Lordship, then DFO, Pake Kesang, and the petitioner had mutual agreement that the rate is fixed at 2,50,000 per kilometer, Your Lordship. That is not true. We don't have that official. We There is no document to show that.
Mr. Brown, any document to show that you have, there's an agreement of 2,50,000?
Lordship, can it pass over for tomorrow?
Not to very good. Because if there is no document,
We had an instruction that they have offered us for settlement of at rupees 8 lakhs. We agreed to the settlement.
that is outside the court, because they can't be the court.
That is the pending amount, Your Lordship. We have not offered that, Your Lordship. We are not expecting.
That is the admitted amount, my lord. So, my lord, that direction may be given, my lord. We don't have any objection.
Yes.
Um, kilometer, CO fare.
My lord, they have admitted in para 8, my lord.
Since Your Lordship, it's a centrally sponsored project, Your Lordship, as soon as they will release the fund, Your Lordship will.
If the center doesn't pay you, pay from your own funds and then replenish that. You see, you did not enter into a contract with them, saying that unless you receive, you can't pay. So that is yours. You don't get central funds, you don't get. But he is required to get.
Six months, Your Lordship, maybe.
No, 6 months will be too long. It's a contract to which year? Contract to which year? 22, 23, 2 years have gone by.
2021, yes, my lord.
But Mr. B. Pichard and counsel for the petitioner, as well as Ms. Arbasa, government advocate appearing for the respondents. The petitioner participated in a tender process for hiring of JCB.
Yes.
And accordingly, ended dated 10/11/2020. Pursuant to dated 31/12/2020. The only a part payment was made to the petitioner and therefore claiming unpaid contractual dues, the present petition has been filed under Article 226 of the Constitution of India. Next paragraph. The respondent number 4, by filing an affidavit in opposition on 17/11/2023, by para 8 thereof, has admitted that the petitioner had executed work amounting to rupees 16,12,500, out of which rupees 8 lakh has been paid, and therefore the remaining amount of rupees 8,12,500 would not be paid, as the the funds under centrally sponsored scheme within bracket Project Tiger was not released. Next paragraph. The learned counsel for the petitioner, upon instructions, has submitted that if it is ready and willing to accept the balance amount of rupees 8,12,500 as a full and final settlement of his dues. Next paragraph. According to the court is of the constitutional opinion that the non-receipt of funds from the in respect of the centrally sponsored scheme is not a sufficient ground for not making payment of outstanding dues to the petitioner who has executed the work. Next paragraph. Accordingly, the respondents are jointly and severally directed to release the balance payable amount of rupees 8,12,500 to the petitioner within an outer period of 3 months from the date of furnishing of a certified copy of this order to the Divisional Forest Officer, Pake PKKE Wildlife Sanctuary and Tiger Reserve within packet respondent number 4. With these directions, the petition stands allowed to the extent as indicated above.
Any interest marked? Interest marked?
Interest,
Yeah.
we'll have to examine. I'll pick some other day for examination.
No, madam. Bless you.
Other matters will have to be rolled over. There is a full court meeting. I have to.
No, there is a meeting.
There's a-
Item number 27 is a matter where we are appearing on either sides. So that the respondent number 3 had filed an application for vacating stay. We filed our reply today. That is probably yet to be tagged. So can it be taken up on 10th of June? We are otherwise in
10th of
agreement.
June.
Item number 27.
The.
नहीं तुम्हारा तो आना पड़ेगा
Besides the third and senior counsel, for the petitioner submits that an affidavit in opposition has been filed by the respondent number 3.
Respondent number 3 had filed an application for vacating stay. We filed a
Actually, the petitioner has filed an affidavit in opposition against the application for against the interlocutory application filed for vacating of stay, which is not a record. Full stop. Mr. D. Das, senior counsel for the respondent number 3, along with his instructing counsel is present. Full stop. Due to paucity of matter cannot be taken up today. More so as the affidavit is not on record. As agreed to by both sides, list on
10th of June.
10/6/2024.
Well, there is an interim order, my lord, that may be.
Interim order passed today stands extended to the next Thursday. Mr. is the same council along with instructing council.
My lord, one matter,
Along with.
my lord. Then we go to.
Ah.
Then one matter, my learned friend is appearing, is the land acquisition matter. NSPC cases, so now we have filed an IA. My learned friend is taking for so many days, I don't know for. So one request, humble request, if possible, tomorrow my IA can be heard. There is an IA which has been filed in that, in item number.
Very difficult.
That's why, just a request is being made. Of course, a request is being made. Because there is an IA
Because
which
there's
is
a
seeking.
difficulty, Mr. Das.
Yes.
The problem is that orders have to be uploaded and then I'll have to be closing the day. That is the main problem.
Only one request. If it is listed, if it is your lordship can't take up, I will, there is absolutely no problem. Only one request. I'm just putting it.
I'm here for so many days.
So one request that your lordship will keep it. And if it's not possible, then your lordship will look into it. Okay.
List.
I'm sorry for troubling my learned friend also. He's there.
My selling will be on my expenses.
I have a full court meeting today.
Today.
I'll have a full court meeting today now.
Full number.
Any other matters will all be rolled
So
over.
tomorrow the matters. Okay. Thanks. Deeply.
Well,
16 item.
Yes.
16. Item number 3, my lord, maybe.
No, tomorrow I'm curtailing my work.
Item number 16.
I'll have to, I'll just examine it and pass orders.
I'm deeply obliged, my lord.
Because you see that, Mr. Mao, that issue is always already haunting. The order passed in one writ petition cannot be enforced by a second writ petition. A contempt would have been appropriate, but contempt, the limitation is out.
My lord,
So second direction I have to examine because I have authored an order which is contrary to the prayer being made by you.
my lord,
I have to retrieve my order because I can't pass orders which are contradictory.
my lord, my prayer is that if it is to be dismissed, I want to withdraw the matter, my lord.
15.
Let me examine because without
15,
retrieving my judgment.
All right.
It's sorry, man. It's not 16, 14, 15.
14:15.
14, 15. Okay.
Because until I retrieve my order, I'll keep your prayer in mind. If the order is, if I can retrieve the order, which is contrary to what you are submitting, then I'll permit it to be withdrawn. Okay. All will be rolled over. And all will be rolled over. The registry will manage it because I can't pass orders.